You
were
I
both
stayed at my
yeah, we
favorite
came this morning.
chain
Oh, you
restaurant.
came this morning.
I love,
Yeah.
what do you guys
What's
eat?
your chain?
Sweet green.
We came this
You're
morning.
eating sweet green? It's
Yes.
a salad?
We landed right about 7:30.
They don't meal and they
Wait,
don't
sweet green or tender green?
Sweet green.
I know.
Okay, I
Yeah,
thought it was
my
green.
first question-
Sweet green, it's on, see, that's actually what I get to, but the salads, I had one in Boston, like just walked into it off the street and it was so good that like, when I landed back in LA 2 days later, I looked it up and there was one by the airport, and I love it, but we don't have one by my house now, so.
Yeah, this isn't a good time.
Yeah.
Why did they change
So
the
I have a
meeting time?
question and
Yeah,
the
well,
answer's no.
We were just giving it a try.
They had to get up at 4 in the
Well,
morning.
Yeah, they're crazy.
Did you?
3:00, 3:50 in the morning I was up to get here. Well, because the thing is, because 10 a.m. is kind of like a no man's land for, like, at least the Southwest.
Well, we were thinking for the returning flight, so people aren't getting home too late.
The returning flight is that's true, that's good.
Yeah, so we were giving it a shot. I guess if it's not better, maybe we'll go back to 11:04.
I would vote for 11.
Yeah, I don't care. I mean, the thing is we'll see, we'll have to see. So, hey, I have a question for you. I forgot to submit my expenses from the previous one. I know there was a deadline. How strict is that deadline?
I think we'll be okay. Just
I'll do it with this, I'll give you. Now it's on.
Mhm.
Okay. Make sure you're off.
And now it's a double.
Who?
Us too. So we're gonna pick up your guys' voices with the overhead mics. You don't have to worry about it.
So do we need this or can we use
I
over?
think Tom was saying for
We need this?
yeah for you guys.
Okay.
I turned it on. Should we turn it off? It's on right now. Okay.
I can even hear you guys. Now Natalie was sitting there, I'm still
Okay.
not able to hear her.
So let me know when we're live.
Sorry. It happened. Sorry.
It's $1 fine. Okay, good morning, everybody, and welcome to California Board of Legal Specialization meeting. It is 10:03 a.m. and calling the meeting to order.
Oh.
Calling the meeting to order today. Adrian, if you would please call roll.
Coulter,
Here.
Esmond, here. Christensen,
Here.
Lester,
Here.
and Torre.
Here.
Thank you.
Do we need to note that there are absences or no, for the record?
Oh, sorry. Levin and Shepard are not attending.
Thank you. Okay, so This is the session of meeting where we have the ability for the public to make any comments. Are there any public members on the phone that wish to make a comment? Okay, hearing none, we will move on to staff reports.
Great.
So Amy, for staffing updates.
All right, so for staffing updates, we have just one update that our recruitment for the program specialist is still ongoing. So we have an active recruitment at the moment. We're hoping to have somebody recruited to fill that position in the month of April. So that is the update on staffing. The next item,
Go ahead, please.
next item is the update on the implementation plans for CBLS, and this is Appendix I implementation. As you may recall, at the last meeting, we had an update on the CBLS rules changes. Where they're at now, they are in an active, open public comment period. It is scheduled to close on May 2nd. Later on this agenda, we're going to be discussing the other portion of the Board of Trustees rule changes, item 702, and we will be getting to that later on today. Another update related to Appendix I is the fact that we've met with the advisory commissions. So on March 7th and 8th, we held 2 conference calls as well as an in-person meeting with the advisory commissions. And what we did at that meeting was update each of those commissions on the decisions that will be implemented as a result of the Appendix I board decisions. And this also includes the rules proposals. So we talked about the rules proposals to each of those committees. We also discussed the formation, as I mentioned here before, of the LEDGE team, that is the legal specialization, exam development and grading team. We also talked about the working group, and I know we'll be discussing that later on today, and the recruitment of graders altogether. In terms of next steps for the advisory commissions, we plan to have a meeting in May, and at which point we hope to have an application that we want to discuss with you here today for anyone seeking to continue as with the CBLS as either advisory, as working group members, as potentially CBLS members, as we have some openings in the coming year, or graders or drafters. So we'll be talking about that shortly. And in terms of the response that we received, overall, commissioners expressed some concern about the process. We apologized about the gap in the information sharing. We also discussed the need for their continuing expertise and what that might look like. And I know I keep talking about this, but we will be trying to gather ideas from this group today to see what that formulates, how we can formulate that. But you know, it's some of the similar concerns that have been expressed at this meeting, and that is losing some of this expertise and how we can find a way to harness that and advance it. So essentially, we will continue working with the group until the the new rules take effect. So what's more, our next meeting with the advisory commissions will be in May. I don't have that, we have May 10th. May 10th. So more to come on that. Okay. The next item, sorry. Recent developments. Just wanted to talk about AIMS. This is our admissions information management system. We got to see it at the last meeting. It was launched on March 1st. Unfortunately, we weren't able to launch the online application for the bar exam as we had thought on that day. So what we've done is it's been open. Most of our applications, we're experiencing technical difficulties with the front end of the application. So most applications that we've received for the specialist exam have been on paper. We're working out those technical difficulties. But specialists were notified about the portal yesterday on April 4th. Oh, today, sorry. that notification is going out today. So, as I mentioned, we've had a few technical setbacks, but we continue to work through those. Next item is the legal specialist exam.
Oh, can I go back to the
Sure.
the aims?
Sure.
Can you refresh our recollection as to the investment that the CVLS made in the AIM system?
Okay. So a $1 million loan was made to the Office of Admissions, and we'll highlight this in the when we talk about the operating statements. $300,000 have been paid back, and so there's a $700,000 outstanding. Last year, there was a need for enhancement. For example, the portal that's required for CBLS required more programming, so to access member services information, migration of data. Initially, the design of the AIM system was a one-time data migration. It turns out that for CBLS, we need ongoing because we have new recruits from member services, so that required some enhancement.
I understand new recruits from service.
So, for example, if somebody expresses interest in becoming a certified specialist, we need to access their file from member services, so in the old system to migrate into the new system. The initial design was a one-time data migration, but that obviously doesn't work. It's going to be ongoing. We're going to have new enrollees constantly, and we also need to it needs to be a data migration where the information needs to go back. Once somebody passes the exam and is actually certified in our application process, we need to also inform the member services, and for that reason, we've had to add some components to the system for CBLS that were not initially part of our scope. We thought we were going to borrow some money from CBLS, but we ended up using admissions funds for that. So overall, it's been a $1 million investment. There are some enhancements that we may need for CBLS. As I mentioned now, we're having problems with the exam enrollment. I'll tell you what the problem is. As I mentioned, we need to migrate the data over from the member services into the system so that we have to redesign and re-engineer the front end. The way the system is set up right now is if somebody logs in and they have existing information, they're able to access it. Unfortunately, right now it exists in the old system, and as I mentioned, data migration is part of that. So we need to re-engineer that front part. That might require a little more programming funds, but we're not sure at the moment. So at the moment, it's $1 million that was borrowed, but there might be a need for more enhancement, and we might need to access some funds from CBLS for that.
Is there a staff member at the State Bar that is identified for the purpose of understanding the AIDS program and working with the software company that was identified to provide the programming development? I know that CB11, who is our public member, played a key role in that. Is there someone who at the State Bar has been identified who has a life expertise as Cynthia has?
So we've hired in our IT department, so we have a lot of, so at this point our vendor has left and our contract is over with our vendor. To continue any enhancements, any other further programming or corrections that are required, our IT department has invested both some time. They've gone to Salesforce training, and at this point we've added one new IT staff person for the State Bar that has a Salesforce background and Salesforce experience. So in terms of as a point person, it's actually a team. And that team consists of people who've been Salesforce trained as well as a Salesforce engineer that's been added to that.
Thank you.
Okay. All right. So that is our AIMS update. And then I was about to start to talk about the upcoming legal specialist exam. It is scheduled for October 22nd, 2019, in conjunction with our first year exam. We will be in 2 separate sites in San Mateo County and in Pasadena. As I mentioned, registration opened on March 1st, for the paper application, and online it opened on March 18th. We, as of today, have 31 registrations, or actually as of April 1st, we might have more that have trickled in since then, but that's where we're at. We want, the members to help us with some outreach, so Adrian will be providing some flyers for you today. If you can distribute those as you see fit, so we can get more people registered for the legal specialization exam, that would be helpful. Okay, and those are the staff updates.
Any questions? Alright, so
Actually, just one thing is working guarantee when there was some interface with the advisory commissions.
And I guess we're probably gonna double back to this anyway later, but was there any, in particular, any feedback with regard to what they felt was the proper size of these working groups?
No, there was no discussion. I think what I put on the table is the fact that we had initially thought of 3, and that might not be sufficient. The number 5 was thrown out there from this group. What we advised the commissioners is that we would be bringing it to the CBLS, and you would help that make determination.
Was there a conversation with any of the commissions with respect to issue of hearing aids versus active?
That was part of the conversation. And so what we talked about last time in terms of the staff reviewing the applications and then bringing forward the more complex applications, and that would be the assignment of the working group. And I'm not sure if that's what you're trying to get at. That's what we presented to them. Yes. Well, it was varied. I mean, I think for the most part, the concern was in terms of replacing working group members. The concern was, advisory commissions primarily was around, for example, exam development. The idea, I think that some people had, was that psychometricians were going to be replacing actual subject matter expertise, and so we addressed that. As far as we alerted them that that's not true, that we're really hoping to create a team of experience either previous authors, and that's something we want to address here, is what criteria we will be using to either recruit for ledge team members or even for graders. So that's something that stands to be discussed here, but that we assure them that a psychometrician will still be used as it has been in the past. Using a psychometrician to create both your weighting and also the grading process is just a standard process for any standardized exam. So that will continue, but that in no way had we planned to use a psychometrician to develop our actual questions. So that's.
Maybe come up with a discussion about the finances, but was there a conversation, or has there been a conversation about budget review on the annual exam for these exam authors and graders?
We didn't have that discussion with them.
Has there been a discussion with the committee about it?
No.
Has there been a discussion with the board of trustees?
What we have is we have a preliminary budget. It's on the agenda today that we developed and had, as every single part of the State Bar House, every office must submit an annual budget. We did that, and our assumption was we modeled the amount of money and what we forecasted based on our expenditures for this year. So again, and it's a little different because this year is a exam development year because it is a year that we have exam development. So next year might look a little bit different. That's one of the things that we had to take into consideration. But we're using our actual expenditures to forecast the expenditure for the future. Okay. Any other questions? Okay.
All right. So hearing none, we'll move on to the consent portion, which is the approval of the minutes from our March 5th meeting. If everybody should have a copy of it in their packet, and it is available online, if we can take a minute to review it. If there's any questions, otherwise we will have to move to accept and approve them. seeing concentrating faces. Everybody need a couple minutes?
I assume here, I assume the under information, I specifically asked for this meeting, we have a balance sheet first as presented. And I don't see in this, this meeting is that information, and I don't see the reference in the appendix. So, would it should it go in?
So what's reflected in the minutes should be motion, so if you had incorporated it into a motion, like I wanna make a motion to add that, I think that, that would be reflected in the minutes. And in terms of, the balance sheet, it is in the form of the operating statement, so I plan on walking through that as, the next agenda item when we talk about the financial and operational key indicators.
I disagree with you when it comes to minutes. I tend to preside over many board meetings, nonprofits, and profit board meetings. Minutes don't only reflect conversations regarding motions. Minutes reflect conversations regarding topics that are brought up at the profit meetings. So I don't believe that these, if that's all you do, then these do not comply with California corporate law when it comes to maintaining minutes for an entity such as this.
Yeah.
So I would beg to differ, and I agree with Mr. Lester that he did request a balance sheet at the time. I believe that should be reflected in the minutes, as that was a item that was discussed and agreed to at that time.
Well, two things. The decision isn't mine as to how the minutes should be incorporated. It is how we are doing it as an end, at the state bar. What I mean by that is what we're reflecting, and these minutes do not reflect that, but they will in the future, is who made the motion, who seconded it, and what motions were made. That is really the standard that we're using for all our entities here at the state bar or sub-entities. So that is how we'll be carrying out in terms of discussion items. That has not been it's not our format.
I would say that this group would prefer that the minutes reflect topics that are concerned to this group, and if there is a discussion, then the minutes should reflect a discussion regarding certain items. That is standard corporate procedure for board meetings. And so I understand what the state bar may do, but I would ask that we have our minutes reflect what a standard corporate board meeting minutes would reflect.
Yeah, I tend to agree with you that there's a lot of discussion that happens in this room that isn't really put into a motion. What I don't want to see us get into is this formality of having to make a motion after every discussion, that the discussion be included in the minutes so that we can then vote on including the discussion, because that's ultimately is what we would have to do, which is silly. And, it's procedural, and we can do it, but I would hate to get into that.
I figured by bringing up the topic and requesting, for time ahead, that, this is where I'd like to see you help me in understanding the financials. That's why I made the request at that point. So we just put that for motion if need be.
Right.
I think automatically as before, there was a discussion about financials and request for a balance sheet at the next meeting.
Yes. So I a little bit out of my territory in asking. I agree, and being no motion, I'm just going to say I think that the interest would be that we somehow revise the minutes to reflect the discussion that was had. So I don't know what the proper procedure is to make that recommendation.
Okay, I believe that in the future, the minutes reflect discussions that were had.
But
I don't see any other motion you're not going to make.
But let me, if I can interject for a second, there is a motion, and I'll have you repeat that in a second. I'd like to address the existing minutes first, and then we can talk about how to handle the future.
Yeah, I think in review of the minutes and
Bless you.
approval of the minutes, I would concur on that just the minutes should be amended to reflect his request.
Mm-hmm.
And I think that I see the problem. Minutes don't need to be essentially a reporter's transcript
Right.
of everything that happens in the meeting. Like, because that would be going down a rabbit hole. I don't think anyone wants it.
Right.
But at the same, I think we can make a distinction between like kind of general commentary and then just like commenting on a particular issue, and actual requests for action or requests for certain things to be acted upon later, which I think this kind of counts as. So I would want the minutes to reflect Mark's request for the
Also, I don't think I abstained from approving the minutes. I may have abstained from something else, but I don't think that's what I abstained from. It says action taken upon which the second adopted of February 15, 2019, so that's when meeting this was approved. I would have no reason not to approve minutes. There may have been something else I abstained on. I don't know what that.
My recollection, there is something you abstained on. My recollection of what it was is a little fuzzy.
I think it was actually item number 3, where we were talking about the
language.
revisions to 7.4, and at the end, Lou abstained from voting on that one.
Yes.
I think that's correct. I think that belongs. I agree.
And to follow up with what Roy said, I think that if we ask staff to do something for us, that's an action item that should be reflected in the minutes. So I would say, Commissioner Lesker requested that a balance sheet be provided at the next meeting. That's an action item that should be reflected in the minutes.
Right.
Because otherwise there's no record of us doing that, and so if they're then we have to move the table.
So can I, again, for our discussion, because I don't want to get into, I want to move that we include this last discussion in the minute. Like, would it suffice for staff that we say, can you please make sure that the minutes reflect this discussion, so at least there's some note on there about it, so that, again, it is our kind of historical record of what transpired, so that the next one, we can go back on first, okay, we need to follow up on this. So again, I understand where you're coming from, that the Bar Association has rules in terms of how you're maintaining the minutes. We would like to increase what's in the minutes, so to speak. And this actually came up last time, because you brought up the comment from the previous meeting, and then we're referred to the transcript and the video.
Right.
Which I shouldn't say nobody, it's unlikely that people are going to sit and watch. The minutes should be the synopsis of the meeting, so anybody could take a snapshot and say, this is what was going on that was important.
And from a corporate perspective, the minutes reflect the history so that we can move forward and know what your history is and act on that history. So if the minutes are not accurately reflect action items and what was stated of importance to the entity, then we do not have the institutional history for the minutes so that they are informed in the proper manner.
Right.
And I think, look, to not necessarily to extent that concur with some of this. I don't want staff to be stuck in the situation that this can transpire.
Correct.
So I think that a fairly clear white line is when there's either an action taken or a request made action. Otherwise, it doesn't go to minutes. Unless if somebody wants to move, like I want the minutes to reflect my comments and edits.
Right.
Unless you say that, I don't think we should use both. Like I said this, you said that.
Agreed. Agreed. It's the spirit of the conversation and the actionable item.
But as long as we're that conversation become 3 pages long.
Yes. So yes. So let's discuss how we handle the approval and or rejection or request for amendment of the previous meeting's minutes, and then we can talk about the motion for going forward.
So I guess I would request that paragraph 4 be added that I asked for that which presented to the board in the next.
Does that read?
Yeah.
So is it motion?
Well, I think.
Motion to amend minutes.
Yeah. All right. So we have a motion to amend the minutes to reflect Mark's conversation and comments about a balance sheet being put on there. And the motion was made by Mark. Is there a second? Second is by Janet. So we're doing a little bit different procedure in terms of voting, because we would need to go down the line and have each person say yay or nay now. So unless there's any dissent, I'm going to ask if we could just substitute the roll call for a yes vote. Is there any objection to that?
No.
Okay, so hearing none, then the motion would pass.
It is okay, it's amended as it is.
Well, that was fast.
No, no, this one. Yeah.
I was gonna tip off the,
Thank you very much.
Do you need that though put in the other place? Because he did abstain from a vote.
That, the discussion regarding 6.74 wasn't an action item, it wasn't really something.
There was a vote that took place. I do remember that specifically that Lou abstained from.
Roy's language was what we forwarded. Like, to her.
It was my understanding that Brady, everyone's.
Okay.
Yeah, it's not.
Anyway,
It
Alright.
was because it's super close.
so do we, I don't know what the procedure on your end is. Can we then vote to approve these and accept these
Yeah.
as amended? Okay.
I'm going to adopt the minutes as amended and as reflected.
Okay. Who was the second? Okay, so Mark was the second. Again, I would like to substitute the roll call. Is there an objection to that?
No.
The motion passes. So the minutes have been accepted. And we will move on to the business portion, which is the report on financial and operational key indicators, and I'll give it back to you, Amy.
Okay, great. So essentially, the key indicators are a standing agenda item for CBLS, and they serve to inform the board on the health of the program. So the first we're going to talk about is the operating statement. So Mark, when you requested the balance sheet, I think is what you requested, we wanted more information about what that included, and I think what you wanted to do is look at both like assets and revenue, and that's what's been attached to this agenda item here. So if you look at the monthly financial results for admissions in December 2018, this is specific to legal specialization, and that's what's been included here. So what we have, it is,
I believe it's page 3, if you're going 1, 2, 3, right? It doesn't have a page number though. And it's the landscape page.
So traditional balance sheet, you have your assets, and then below that you have liabilities and
so
so how do I explain what this bottom part is that information?
So I guess what I want to say is two things. One is we're supplying what we get from our finance division. So, our frame of reference is our annual budget. And we, at this point, have, these are closing the books for the December 2018. We do annual budgets based on calendar year. And so in terms of assets, and I think in this case, because our frame of reference is the full year, what we have is the December expenditure compared to the actual year. So we have the monthly expenditure and the year expenditure.
I've got what you're saying. It's okay. But that is nothing operating statement.
Mhm.
But I want to see because we have that discussion. We had $1 million loan from CBLS to the state park, right?
Yes.
So the CBLS would have an asset in this case with the cash plus this note. It's payable back, referenced by, however it's documented in the internal records. So CBLS by itself, this sub entity has got these assets that it has some liabilities.
Mm-hmm.
And whatever the liabilities are, its operations are there. And then the net is going to be what your equity is.
Mhm.
So you tell what this part of the state bar has under its control. And this doesn't tell me that.
Yeah, and I guess two things. One is that I don't know if we have a report that comes across that will convey that. I mean, if you look here, you could see the transfer of those funds from admissions to the CBLS budget for this year. As you know, that is how we view the budget.
Is that $100,000?
Yes, it is.
Okay,
Yeah, that would be transfer revenue, so that would be transferred in.
Yes,
right?
transfer in.
Okay, but you have an expense out of $1 million.
That happened in a previous fiscal cycle, which is why it's not reflected in here.
Right, if you're making a payment on a note to the CVLS, $1 million loan, there has to be, as Mr. Lester said, there needs to be a balance sheet that reflects the asset as an appealable, the specific interest rate on, as an asset in the balance sheet. Where does that balance sheet exist?
We don't have that. I mean, I guess our budgeting is based on calendar year. So I'm afraid you're asking for something that we don't.
You must have, because there's a note payable. So in accounting, you have double entry accounting. You have debits and credits, you have assets and liabilities. Someone has to look and say, okay, first of all, there's an asset of the CPLS for $1 million. It's a note payable. It's at this interest rate, and we're going to pay that whatever the agreement is in installment. So that is on the CBLS, it's an asset that has value to CBLS. On the state bar side, you have a liability, you have payable, and this is how accounting works.
You can't have payment without an allocation. And here, we just have money flowing around without telling us what's the basis for the money in or the money out. And that's what's confusing and makes it difficult as a board to say, I see what your ongoing operations are, but I don't know what is the whole of the entity itself. When I don't know.
Well, it's also going to drive me to my next point. So one of the decisions as part of Appendix I on the part of the board is to remove the functionality of finance review for sub-entities from the sub-entity to the board. So, for example, on this agenda, we have the budget for legal specialization for this year, but this is probably going to be the last time that we present it. This is going to be a function that's carried out by the board, and in terms of whether it's operating statements or overall financial risks and evaluation of those financial statements, that will be a function that's carried out by the board.
So how is the CPLS supposed to account for the repayment of those funds?
That will be something that will no longer be carried out by the CBLS. It's
So
going to be
those
carried
funds-
out by the board.
So those funds will not be repaid?
No, those funds will be tracked by the board, not by CBLS. And
So in
it's
other
done.
words, it's trusted. We won't spend money.
Well, actually, all of the financial discussions are on the board agenda. So if you want to see how both the funding moves and gets transferred from one unit to the next, or how the entire financial operation happens, it will be on the board agenda.
But the funds for $1 million came out of the CPLS budget
Yes.
from the fees paid by the certified specialists and
For this program.
for this program.
For this program.
And so you're asking the debtor to keep track of the debtor's payments to the creditor, and the creditor will be kept in the dark
Actually,
as to the receipt of funds.
yes.
Yes, that's
No,
correct.
it's
Thank
not
you.
kept in the
Thank you.
dark because it is something that's posted on the board agenda.
But
I
you're, and think about it. You go to a bank and borrow money. I'm not going to tell you anymore, Mr. Connector, when I'm paying you, how much I'm paying you. Trust me when I tell you I'm going to pay you.
That's actually not what we're saying, or what I'm saying. What I'm saying is that this action of reviewing the budget and tracking the funding is going to be carried out by the board, and it's done with a public notice with under Bagley-Keene, so it is attached to a board agenda, and that's how it will be tracked. It's a function that's no longer going to be carried out. For example, for the Committee of Bar Examiners, they're no longer conducting any financial reviews. That's being conducted by the board. And so we're the same thing with CBLS funds and the CBLS funding and budget development will be carried out and tracked by the board.
Are there any other funds that CBLS has loaned to the state bar over the last 5 years?
Aside from this $1 million, I'd have to look into that.
Okay, I'm making a request
Mhm.
that staff provide us with a report of any other monies that CBLS has outstanding again, I'm requesting that staff provide this board with a report on any and all outstanding assets that are being by the state bar to the CBLS.
Okay.
Any and all.
You want that at the next meeting?
Yes.
Okay.
Adrian, did you get that? Okay, great. I mean, and the complexity with that too is that we're no longer going to be monitoring the budget. I mean, this is probably going to be the last time that we, the key indicators will include financial information.
So I would object to that as still an appointed member of this committee, whatever it's going to be called. I would object to that action being taken. And as a public member, as a dues-paying member of the state bar, as a dues-paying member of the CBLS, as a taxpayer in the state of California, I would object to this commission losing that oversight. I am very seriously concerned, given the history of the state bar in the last 7 years, its inability to track money. And to remove that oversight from us, I have very serious concerns with that issue. I absolutely object to that.
And I would concur with things on very basic topic. I'm very concerned that as a member of the body that authorized these loans, we will now be essentially kind of flying blind to them. And I understand that for efficiency's sake, it would obviously be better to have this, be at the board of trustees level. But frankly, I don't know how we function without any basic oversight of, at the very least, the sizable loans that we've made to other portions. I don't know. I mean, somebody can educate me on that. Maybe I can be persuaded. That seems like a fundamental function that's being taken away that makes it difficult for the CBLS to be the CBLS.
As well, the inter-fund allocation of $847,000. How can we have oversight over the taking of our members' monies for that purpose? We have to have oversight over that.
And when you say oversight, you mean you want to make the determination whether the interfund happens or not?
I want to ask, what is it? Why is it? Because as Ron said, we have approved these over the years. This is my 11th year doing this, and I have a duty. Mm-hmm. I have a duty to, as a member of the state bar, I have a duty to the members of the public, I have a duty to the certified specialists that I'm responsible in a way to know where the monies are going and for what reason. Mm-hmm. And to ask, and to say, to instruct staff and say, I'm wondering why. Mm-hmm. Because someone's going to come back and say, why didn't you ask?
Well, and let me just say this. I completely understand the concern about the oversight, but I don't think that there is a move to hide the financial process. I mean, it's going to the board. It's going to be carried out by the board, and anything that happens that way is noticed. So rather than these reports going to you, they're going to the board.
But if there's nothing to hide, mm-hmm. then the process that we've been in should continue. I'm always concerned. I always say to clients, as soon as someone says to you, trust me, run as far away as you can. Okay? And the board of trustees is saying to us, trust us. If you're to be trusted, then continue to allow us to have this oversight over our members' money.
And I would just my concern isn't necessarily with these monies going away or there being some like or not being able to see the folks. That's not my concern. My concern is as the body that authorized very sizable loans to other parts of the world, we are now going to be in a position of having zero oversight and control over those various things. Zero liquidity.
Right.
That's
Unacceptable.
I just don't know how we do what we do without some formal part being some formal part of that process.
Well, I think the next step is that we are not going to do it. We're not going to do anything.
That's certainly what it feels like.
Well, it's technically in the way.
True.
Sorry, I was looking online and I cannot seem to quite figure out it. At some point in time, and please correct me if I'm wrong, there are bylaws for this subcommittee, is there not?
There's organization.
There's organization, and there's rules.
No, but we had specifically for the California Board of Legal Specialization, and for this, I believe that at one time or another, in a packet, and I don't have my binder with me, I was joking about that earlier, there are actual kind of rules of engagement for
I
this.
believe you're right.
And so I would love to be able to review those, but I can't, I was searching through the California State Bar's website to try to find them. I'd have to go through my old emails and whatnot, and I don't want to be distracted from the meeting, but I would love to, maybe at a break, we can try to find them and we can review them, because I think that we also need to understand kind of where we stand from that standpoint, right? Is something changing that we believe is part of what the rules of order are?
Well, if we have rules of order for our committee, shouldn't they be on the state website and accessible? I mean, we have to have this public meeting, and everyone has a right to listen to them. I think everybody has a right to know what our rules are, and they can't just arbitrarily be changed because someone decides they want oversight and don't want us to.
And I don't mean to throw us on a left turn. That's why I'm asking the question. But I believe that I've read those at one time, and I'd love to review them.
Yes. So, and so you're referring to the state bar rules.
I believe. Well, I know that there's
a
state bar rules.
entity has
Has its own rules.
of order or bylaws.
I believe that they were bylaws. There was one notice about how the formation was, and this was when I first was put onto the board. That detailed that it was the 1972, the state Supreme Court dictated that this was there, and then there was a second document again, if my memory serves, that was actual bylaws of the California Board of Legal Specialization.
I believe that's correct.
Yes. And if this entity is an entity that adopted those, then only this entity can amend them.
Right, and as it falls up, obviously through the hierarchy, like, can things be changed that easily without there being some sort of actionable item? So I just can't find it in a simple search, and like I said, I don't want to be that distracted from the meeting where I'm Google searching for the next 20 minutes. So.
So do you guys mind looking for those on our website?
It was not about the actual attorneys and how the attorneys become a specialist. It's a governance of what this committee's oversight or this board's oversight was and its rules of order.
Chris, it's bylaws of the how an entity governs itself. So I believe there's something that talks about like how many members we are, how they're chosen, how we bring up issues, how we vote on things, what our functionality is. There should be, and there are bylaws or practices and guidelines as to how this body governs itself.
How we function.
Mm-hmm.
So yeah, so if somebody could find that, that would be great. Or like I said, when we take a break, I can go back through my old emails and try to find it as well. Because I remember reviewing something before I even filled out my application to be a board member.
Agreed.
Okay, so I think we need to get back on topic of the actual numbers that we're looking at here, and then we can move on and have further discussion about this.
I think that the action here is to move the report that we received to the file.
Basically, yes, is that we've looked at it, and then we can have further discussion about what does that mean.
Right. We're at the first stage is just proving that we've seen this and we're fine.
Correct. Right, so let's let Amy get through, because I don't think we made it past page 3 yet.
So,
You said it was gonna be a fast meeting.
I'm sorry.
So just to wrap up on this indicator of the operating statement, what the December 2018 report demonstrates is that the program is operating appropriately. The budget is apportioned to match the timing of the expenditure for that month. The next report is about program growth, and it's looking at the number of specialists compared to last year. And as you can see, the total number of specialists has experienced a slight increase from a year ago. The next report is related to resignations. As to the total number of resignations for 2019, this is as of March 1st, we have 62 resignations. The majority of the 2019 resignations are due to retiring attorneys. And given that the program is in its 37th year of certifying, we can anticipate seeing more retirees. Lastly, as part of the process of maintaining one certification, certified specialists must take 36 hours of specialist approved continuing education or an equivalent. And this report tracks the compliance for every 3 years, and we're currently tracking compliance for compliance group 1. We have 278 outstanding compliance compliant applications in this group as of March 1st, and staff plan to continue follow up with this group. So any other questions related to the key indicators? All right.
Sorry, I was just something there. So that being said, that completes the review of financial and operational indicators. Is there a motion for us to receive them as opposed to approve?
Yeah.
There's no approval. It was just a game.
Yeah. I moved that we receive.
Okay. So there's been a motion. Okay, Roy's seconded, and again, I will submit the roll call unless there's objection for the vote. Okay, motion carries. On to item B, the report on legal specialist examination, successful applicant post-examination status metrics. And this is over to you, Adrian.
Sure, so this item is tracking the successful applicants of the 2015 and 2017 legal specialist examinations. At the last CBLS meeting, the CBLS approved an extension of time for those who passed the 2015 exam to submit their post-exam application for certification. And that new extension date is May 31. As of March 1st, 87.7% of the successful applicants have already filed their applications. We did send a notice to the remaining ones that there was an extension, and we'll be continuing to follow up with them so that they submit their applications. For the 2017 exam passers, they have until the 24th of this month to submit their post-exam application or to request an extension of time. As of March 1st, 45% have already filed their application, and we're expecting a further increase of applications or extensions as that 24th deadline approaches. Any questions regarding the attachments of the item?
More out of curiosity, so there are 2 people that they said they do not intend to continue, yet they passed they passed the exam.
Mm-hmm.
And it appears so we don't know really why. I mean, they may just say I don't want to do any of the.
Correct. There's no form to request or.
They just said no, thank you. Got it.
Just to add, there's been a variety of reasons. Some people, they start with one area of law and then they move within the 5 years that they have to file the application. They change their practice or they decide not to pursue it. So.
Got it. And I was just curious.
For example, 1993 or 91, I passed an exam for the estate planning. By the time I was submitting my application, I'd gone to in-house counsel, so I no longer had 25% of my practice as estate planning, so I couldn't.
So you couldn't do it. Got it. All right, thank you. I was just curious. Okay, and I believe that's everything from your portion, Adrian?
Is there a motion, sir?
Yeah, so do we have a motion to receive the report?
So, second.
Okay, so the motion is by Roy, second by Mark. Again, I will submit the roll call as the vote, and this is an objection. And hearing none, the motion carries. On to item C, the approval of the advisory commission and staff recommendations regarding certification and recertification. And that's Crystal.
Right, for this item, there are two corresponding attachments. The first is the recommendations from the advisory commissions for certification and recertification. It's the list of a lot of applicants who were recommended for approval. The second is another list for certified specialists who have not recertified as of March 1st, 2019. We would be seeking revocation of their certification status. Of course, they would receive notice before we would change that status.
Any questions for Crystal? Does everybody need anybody need a minute to review? Okay, so we're gonna take a minute to review the lists.
Looks good to me.
Good. Okay, so we need a motion.
I'll move.
Okay, so we have a motion to approve the recommendations for certification and recertification.
Abstain from workers' comp.
And with the note, that we'll have the extension from workers' comp by Janet. Is there a second?
Second.
Second by Roy. Then again, noting the abstention, we will submit the roll call. This is an objection for our vote. Hearing no objection, the motion carries. On to item D, approval of the interim advisory commission officer appointments, and Amy.
Yes. So the member originally confirmed by the CBLS as vice chair for estate planning, trust, and probate law was done erroneously. So we had to correct that, and so this is request that the EFLAC vice chair be reconfirmed, and it's recommending it's a public member for appointment.
Jerry's a good guy. I like him.
Are we okay, or do we need to wait for?
It would still pass it if you did
Right.
vote.
Okay,
Yeah, I don't have a problem.
we technically need to take roll with them being absent from the vote. Okay, so yes, is there a motion to approve the interim advisory commission officer appointment?
I'll make the motion.
I'll second.
Okay, so motion is by Mark, second by Roy. As we have a member that stepped out, we're gonna actually take a vote on that. So, Adrian, if you can take a roll call vote.
Coulter,
Yes.
Esmond, Personson,
Yes.
Lester,
Yes.
Torre.
Yes.
Okay,
That's
so
enough votes.
motion carries. And we will then move on to item E, review of the National Board of Trial Advocacy application for accreditation of specialty certification program in truck accident law. That's a long one. There's
Yes.
Amy.
All right.
So we have the CBLS State Bar approved certifying organization, the National Board of Trial Advocacy, NBTA. And it was accredited by the ABA in August 2018 in truck accident law. They are seeking approval or accreditation here in California. Current California approved areas for the specialties under this entity. We have 82 civil trial advocacy, 8 in criminal trial advocacy, 5 in family law trial advocacy, and 5 in social security disability law. So given, we talked about this at the last meeting, the application was forthcoming. We brought the application for this group to review. There were no more recommendations for modifications to that application.
So, given that we have this in-house now, it's been attached as this agenda item, we propose three separate options. The group here can either approve to forward this recommendation to the board and add this as a certification area for CBLS, or we could also request more information if the group feels that we need to review the application with greater scrutiny. Perhaps there's something else that needs to be addressed. Or lastly, we can deny the request on this application. So that is the agenda item. And if anybody has any discussion on that.
Staff's recommendation was to approve and forward.
No, staff's recommendation, staff included three recommendations to,
Well, all the three recommendations cover like the entire ground though. None of them are recommendations. It's like three options, but the three options are approve or deny.
Leave it to this group.
Any discussion?
Do you have all, that's probably right. The number of people nationwide who are accredited instructors. Look just back and forth.
It's in there, but
There's just a lot of numbers. Call like
Maybe it's just me, but page 60 is their membership list. I don't know if it's really that small. Or
Say that again.
page 60 of the attachment.
So 60 is the last page. Yeah, so that's
I don't know if it's that small nationwide or if they're only showing the ones that are here in California.
certified. One is certified in January of 2019, the other one's certified. So that's two. Two. And one is not fixed by 20. So we'd be talking about one person in the state.
You just got certified currently in
A few months ago. I don't have much.
what I'm trying to flesh out is like if
It's a pretty, it's area, it's sponsored the Ford Trial agency, which obviously has a great track record and we've worked with for a long time on obviously bigger certifications. This is an awfully too spot, maybe a little bigger, not sure. I don't have a problem with this. Okay.
So there are fees they pay us,
There would be if approved.
and how is that based upon how many specialists they have in the state?
Correct.
So there's one.
Correct.
And so what would we be receiving for that one?
It's per specialty, and then there's and it's done by the year. So there's a per specialty fee, and then it's a $25 per specialty.
So approximately
Like $220.
200. And approximately what is the cost
Thank you.
to the CBLS for administering this program? with
One
One person,
I,
yeah. That was gonna be my question too. It seems like it's a money loser, if you will, or it costs more for them to administer one person.
You see, this is a financial question that obviously is before us, that if we go back to our prior discussion, we would no longer have the ability to answer that question.
Now that's the national board is one that is.
No, I'm saying the question that cost to the program
Goes there.
okay? That's why it's a critical question, is fine. So $225, we don't know what the cost is to administer this one member program,
We probably already spent more than $225.
or at least between.
Just in three staff members' time alone, and taking applications.
Right, isn't a lot of times whenever there is an actor, it's so low that we have concern about whether or not we can continue that. And there's more than one member. I'm concerned we're spending a lot of time for this enriched area until it becomes more substantial.
I think we need to have some sort of threshold in place that says if it's not X number of members.
Fair enough, but I mean, to play devil's advocate, we're essentially saying we have a very good long-running relationship with the National Board of Trial Advocacy. They have approved this program. So I think, in essence, what we're saying is that if it's good enough for the MBTA, it's good enough for us.
Yes.
Under that reasoning, I'd actually would approve this because if the MBTA is perhaps since it's such a new program, that's why there's only one person that's in. I would actually.
So, to follow up to that, if we were to approve it, do they think it would grow the program with greater momentum because it is being made a part of or blessed by whatever we would call it in the future?
Well, there may be a chicken and egg problem too, where the MBTA might want to grow the program through the reciprocity with the California with specialization, but if they don't have that, then there's not going to be incentive to do it, so it can't get off the ground. And I mean, frankly, this is my personal bias. The MBTA is civil trial advocacy, criminal trial advocacy programs are so top-notch, and they take their standards very seriously. Such that if they have certified this program, I have, and looking at the application, like Big Five, all the across the team, I have confidence in the program as a whole. Even though there's now, to this point, one attorney in California, I would be comfortable.
So
recommending.
So your peer review as a fellow professional would advocate that we have reciprocity with the trial
with the
MBT.
MBTA.
and I guess going back to the price, I guess the MBTA is the one that does the legwork regarding administering the program. I guess in processing like the annual renewal, or I mean, I would say at most one person would spend 8 hours in a year in just processing.
But one person at an hourly rate of $40 an hour is $400.
Every marathon starts with one step. I guess so we have one attorney that's currently certified from California, but this barely got off the ground, and maybe I'm a voice of one on this.
No, but I think your point is that if the program is in the upswing, then it's a good, but if it's dwindling,
And if it's a program that they have adopted and they put their resources to,
yeah,
and
they
this-
had to believe in
this
it.
being 12% of the U.S. population, God knows what percent of lawyers, this might be the place where they plant their flag for this program and grow the program. And if there's no downside to us having reciprocity, then it could be good for all concerned.
I don't think we need to look at it as a money maker. That's not the point of it. It's just, can it be, we just don't want it to cost money to administer a program that has no possibility of at least covering itself.
This is fundamentally different from us starting a new California specific specialization.
Right.
Where it happens to be there's
one attorney.
Right.
Different.
Right.
So like that's my initial numbers thing. I'm sorry, I'm going to read your loss. I just want to know how it had gone. It's starting into the bloodstream, how it slowly
Right.
to the general population. Because the application is
Well, and nothing should stop the group also from maybe asking about what their plans are for program growth, like what kind of outreach and so on and so forth.
Wouldn't you think that before they approve something like this, they might want to do a little bit of research into whether there are people, attorneys, members of the state bar, who would actually be interested in having this certified specialist?
well, there used to be back circa about 1992, huge company business, being in the business of getting the permits all, and then when it became regulated, that whole industry was wiped out. This is, this is not back in that regulation department, but it's the other side of the coin with respect to the trucking industry.
So I hate to introduce business concepts into a bureaucratic agency, but if I were them, I would attach this kind of business short pitch deck, right? So this is what my plan is. Oh, okay, thank you very much, and we understand it. But business has
It's also very interesting, truck accident law and trucking and all of that is an interesting, area to discuss anyway, because as automation changes, right, and we have self-driving vehicles and whatnot, there's a possibility that there's going to be a lot more attorneys interested in this space, right? So, because there are going to be problems that happen as we automate and we go to driverless technology. So, again, I don't want to argue over whether it's a moneymaker because that's not the point.
I have another question. Is there a list that we can look at that tells us how many specialties the National Board of Advocacy has approved?
Well, it's the ones that we have.
Right. For
What page is that? Because I thought it was rather short.
First page of this 3D.
Oh, here it is.
So we have civil trial, we have criminal trial, we have jury law trial, and social traders, both.
It's a large amount in terms of our certifying partners because usually there are about 1 to 2. We have I think 4 or 5 partners with 1 to 2 specialty areas with reciprocity. MBTA I think is the largest.
No, I would move that we approve. I believe that it reflects well on the program and I echo Roy's advocacy for it and move to approve it.
I have a question before it gets approved. Because we'll be presenting this to the Board of Trustees for approval, would it be helpful for us to reach out to MBTA for just kind of a summary memo instead of this full application saying this is the plan, these are how many attorneys we put back, this is the reason we want to have a specialty. I don't think it's like outlined in a clear format for agencies to review, but we can ask them to provide that to us as clear rather than maybe.
But what spurred it, the idea? I mean, there must have been some sort of groundswell.
Yeah.
No, I would say that provide us with a short business plan. How do you intend to grow the program? What is your value for marketing program, for soliciting new applicants? How do you plan on vetting them, whatever? I think that's my basic business plan that we set out over the 3 to 5 year period of time. How do you intend to grow the program? Right?
Right. Adrian's putting after we see the state plan for
Truck, so to purchase after state statement. I would do like a business plan.
According to their website, there's 1,500 attorneys practicing truck accident law with an additional 1,000 participating in a limited capacity. So according to the MBTA's website, the universe of attorneys in the area is 2,500. That's for federal
Nationwide.
nationwide.
Attorneys practicing in the area.
So the exact is over 1,500 attorneys practice in truck accident law. An additional 1,000 lawyers participate in a limited capacity.
And we don't know the number for California.
Now that's national, correct?
But I agree with Rob that this may be an area of the law that will evolve given self-driving vehicles, the introduction of AI. You're going to have digital platforms where drivers are obtaining work from trucking companies.
Correct.
So this may well, there's a lot of issues that come out of it. It does get some legal law.
My opinion is you've already established that the MBTA is reputable and we have a relationship with them, and so there is no negative to accepting the program, right? Other than there could be a small financial, right, that to administer the program, but
Right, but if all we're doing is asking to approve the program for one person,
right,
then the administration internally makes no sense.
correct.
But if you've got a long-term goal, we see potential for tens, maybe up to 100 or 200, in California, then it makes sense to us.
So let me ask from a timeline perspective, if we don't accept it today and we say we want additional information, we want to see the business plan, we get together, when are we affecting any timeline that would go on with the state bar's board in terms of the acceptance of the program?
So the next board meetings are in May, July.
Okay.
So then I guess it depends on.
So if we don't accept today, it's going to go to July,
Mhm.
basically. So that's the other thing we have to keep in mind. If we approve today, they will be on the May agenda. If not, it goes to July.
No, I like how we did it.
Yeah.
After you said a great business plan detailing program work. In California.
I'll just say, I'll vote for this. I would vote to approve it today. I mean, this is the gold standard of our partnering agencies. And perhaps I can a bit more, not necessarily blind for it, but very trusting things.
I don't. I'm sorry. I
Yeah.
don't mean to cut you off. I don't like this, to be honest with you, because that unless there's a review of what they're submitting, it's a silly request. I can give you a piece of paper. We're not saying we're going to review anything. It's like we're going to approve it and send your business plan, but either we're going to approve it or we're going to see their business plan, review their business plan, and approve it.
So what do we modify and say recommendations conditioned upon receipt review?
But then we're not accepting it, right, until our next meeting anyway. So then we're tabling it or rejecting it at that
No, we're
point.
telegraphing to the MBTA that we intend, we more likely than not will approve.
Right.
But we want.
Right. So that's the second option, requesting more information. Right. We were given three options by staff: approve, request more information, or deny the requested application. So we're going to request more information from them as to what the potential growth of the program is and how they intend to do it. Right. I just don't like it having that kind of open-ended.
I have another suggestion. I don't think this option is here, but we can also form a subgroup of 2 members of the CBLS to make that determination if you want to accelerate the timeline and have 2 people review the business plan.
We're few as it is.
Okay.
We're not 15 minutes, probably.
Yeah, I would like to just again. I know we have a motion. I believe we have a motion on the floor, but that I would like to have a discussion about making the motion to approve with a request that for the Board of Overseers, they actually submit their business plan for their review as well. I don't know. I just don't like saying contingent upon you submitting something and then we don't actually review it.
That's a motion.
Okay. Any more discussion, or we have to take action on the first motion and then we can decide what we want to do?
Mhm.
So, okay. So, knowing that there may be a second motion coming from Roy, we'll take action on the first motion, which is Reggie. Is that the one you're highlighting there?
No. So it's this one.
Okay. So the motion is
that the recommendation of accrediting MBTA's specialty certification program in truck accident law be approved for transmittal to the Board of Trustees after receipt of a brief business plan detailing program growth in California. So that was the motion.
Friendly amendment, which is to be provided prior to whatever the date of our next meeting is, so that we can have the agenda and vote.
Okay,
I think that's the second motion.
Oh, okay.
right, so is there a second of this motion, or does this motion kind of just drift into the sunset?
You don't like
Okay, so is there a second? Are you withdrawing your motion, Lou?
It's my motion.
Yes.
Second.
Correct.
I'll second it.
Okay, so we have a second. I think we are going to have an actual vote on this one.
And which motion is it?
So this is the motion that is highlighted on the board. After the recommendation of accrediting the specialty program be approved for transmittal to the board after receipt of brief business plan detailing program growth in California. So, Adrian, would you like to?
Coulter,
Yes.
Esmond,
Yes.
Christensen,
Wow. I actually vote no.
Lester.
No.
Torre,
Okay, so the motion does not pass, does not carry. So now we're gonna have, yes, please.
I move that the recommendation of credit MBTA's specialty certification program for accident law be approved for transmittal to the Board of Trustees.
Second?
Second.
Second by Mr. Esmond. I think that since we had the last one, let's actually do a vote. Adrian?
Coulter,
Yes.
Esmond,
Yes.
Christensen,
Yes.
Lester.
No.
And Torre.
yes.
So the motion carries. Okay, so we're up to section F, which I believe in looking forward is going to be a rather lengthy discussion. And so I wanted to bring it to the group. Do we want to take a quick bio break? Do we want to break for lunch early? How do we want to handle this? Because I think it's going to be rather lengthy. So anybody have any opinion?
All of it.
Yeah, the wrong thing to say. Any have an opinion that I want to hear? Early lunch is okay. I mean, I see the lunch is in the back of the room. So let's take an early break for lunch. It's 45 minutes acceptable for everybody. Good break. So right now it's 11:21. 12:30. 12:15.
12:15.
It's not going anywhere.
No, well, the earliest flight I believe anybody has is probably 4 something. So you leave on Sunday. So Monday. You're even farther out. Okay, why don't we shoot for 12:15 because we know that really means we're going to start at 12:30. So we're going to adjourn for lunch until 12:15, and at that point we will continue with section F. And then we'll know when we're offline. All right. welcome back everybody from lunch. Everybody had a good lunch, so we are going to resume the meeting 12:13, 2 minutes, well, now 12:14, just 1 minute early, with agenda item F, the review and discussion of Board of Trustees item 701 regarding California Board of Legal Specialization State Bar Rules Revision, Title 3, Division 2, Chapter 2 Rules Changes. And with that, I will give it to you, Amy.
Okay.
We have attached the board item 701 to this agenda item that highlights the rules, proposals, revisions to the California Board of Legal Specialization rules. As part of this discussion, we anticipated also discussing the formation of the ad hoc working groups, specifically, a discussion on what that composition might consist of, what some of the requirements might be, and also what the purpose of some of the what the purpose is for some of the newly defined roles. And so prior to that, before we get into that conversation, I just want to find out if anybody has any questions, concerns, or comments that they want to raise related to the comment rule changes. Where it's at right now is it's in a public comment period, as I mentioned earlier, that's scheduled to close on May 2nd. So are there any questions related to the board item 701? Okay.
This is the same as we saw a couple meetings ago.
Yes, this is the same one. There are no changes. They actually don't go to the board right now during a public comment period. They have to go to to Adrian, who gets it. Oh yeah, all comments are going to Adrian. Sorry, I was thinking about.
So Adrian, have you received our comments?
And so they get compiled and reviewed by our attorneys, General Counsel, Office of General Counsel.
So the comments at this point are simply collected and digested?
Evaluated yet until it closes on May 2nd.
And then for my edification, what does that mean? Then once it closes and they're now reviewing the public comments, like what then happens? Do they, every public comment, vote to either take action, pass, again, just from my understanding of what goes on with those public comments?
So they get organized for the board in a way that highlights all of the different positions. So, in this case, we don't know, where it covers so many different areas that we're not sure how it will be designed. But the idea is to present to the board in a summary form, all of the different perspectives that have been presented. And this is a lengthy list of rules. We also have, for example, in a previous cycle, a summary that went to the board with a staff recommendation.
Mm-hmm.
And so, depending on how, it's really contingent on the amount, the volume, and the different perspectives that we receive
During the period.
During that period.
So it says members, so we know that we're members of the state bar, right?
Yes, everybody's become a licensee, and that's a global change that happened outside of even CBLS. It's for all our California state bar rules.
And someone who's a certified specialist, what would they be referred to as?
I believe it's still certified specialist. The difference is certified specialist by the state bar versus certified specialist by the commission or
The California Board of Legal Specialization.
exactly.
So certified specialist, which was typically always or something like that, right? That was a question I got.
Certificate of holding.
I was asked by some of my fellow certified specialists if we're no longer members of the state bar, we're licensees. Will we just be certificate holders, not certified specialists?
I have not heard that, and I don't believe it's in
Because
our proposed rules.
cafeteria. I can go to Walmart into the stations section and get myself a certificate, my name on it. And so people just want to make sure that they have a reference that has some type of meaning to it.
Well, it's like this, we're licensees as opposed to members.
I think with licensees, because regulatory agencies license, whereas trade associations have memberships.
Okay.
So
they can still have the store, like,
Privileges?
no, they can look at your actions, suspended, or whatever, I can't put somewhere else.
that's regulatory.
I
think that's the difference.
It's interesting though, from a consumer standpoint, when I think of licensee, I think of you're paying for the right to say that you're something versus a member means you belong to a, so it's, I know it's semantics, but as the public member, to me, it holds more weight for me to hear somebody say they're a member of the state bar versus a licensee of the state bar.
This is one of the ones that-
Oh, yeah.
Well,
Still
I think
eligible.
your point is the becoming a member of the state bar was becoming a member of an honorable profession.
Right.
That is the movement.
Yeah, to me, a license implies you're paying for the right to say you're something. That's a license.
That's correct.
So again, I know that's not what the purpose of this is. I'm just saying that the public,
The vernacular.
it has a different.
But that's why you're a public member, and it's good to get that perspective. And I know this is a fait accompli, but it's the perception of the public that, oh, he's just a licensee.
Right, but it's my understanding that nothing in this essentially change in, nothing in this change in nomenclature is gonna keep people from representing themselves as certified legal specialists.
That was.
Right.
I
Or somebody saying that they are a specialist and the bar association not being able to go after them and say, you cannot represent yourself as that.
No, you
Well,
actually, you can make reference to yourself as being a specialist, but you
Not
can't make
certified.
reference to yourself being a certified specialist.
And this change also does not alter the process that exists now. If a member of the general public wants to look up an attorney
Mhm.
to see if they're truly, certified, that will still exist in member services and on our public website.
So one of the things that comes up is when a lawyer is in the public domain and they continue to make reference to themselves as a member of the state bar, what is the effect of their using the wrong nomenclature? Is someone supposed to now stand up and say, I'm a licensee of the state bar? Because that has, as our public member, Mr. Hershenson says, that has a different public perception, sorry.
Our rules govern, how we refer to the members. So what he's
The
or
licensees.
the licensee. So in terms of what somebody uses, there's going to be a transition phase.
Right.
I mean, if you look at some of our forms now, it's all contingent on these rules being accepted and advanced. But we have reference to members. So, I'm not sure if your question is whether we could take disciplinary action on somebody who's calling themselves a member. Obviously that will happen in a transition phase.
So I have a question about that. So this same with if you're an organization and you change your name, right? So there's a cost associated, a true dollar cost associated with rebranding, which is ultimately what this is, right? We're rebranding from being a member to a licensee. And in the case of the specialty program, saying, how it's going to be. So are we expected as the board to kind of police? How is it going to be gone out there and communicated to the now members, future licensees that are certified by the State Bar of California, that they're going to have to change their business cards potentially, they're going to have to change their websites, they're going to have to change anywhere that they've printed that they are certified by the California Board of Legal Specialization. There's a real cost to the attorneys and to us as a program. So has that been addressed?
The process or the cost
No,
itself?
no, there's a real cost
There's
to
no
the,
cost.
there's a real cost to the now members, future licensees. Letterhead changes, real dollar amount cost to them. Is there going to be a period that we're going to allow the current legal specialists to continue to use their branding now as they go through their existing things? If there's not, is there some sort of avenue for them to submit for reimbursement? Are they just expected to eat the cost? That I can only tell you from being at Universal and having our division's name changed, it's a lot of money. It's a lot of work. If you have to change a website, you have to pay your web developer. If you have to have your voice, the voice dialing, changed, you have to hire the person. Business card. So there's a real cost to the individual attorney that I just thought of sitting here that I think should be discussed in terms of, are there avenues for them to use what they currently have, or is this proposal a hard deadline of this date, you are no longer this and you're that?
I don't believe this is a hard deadline date, so as I mentioned earlier, I think it's going to be a transitional phase. I mean, whether it's our website, whether it's somebody's stationery, letterhead, business cards, this is not an overnight change that we're anticipating.
Okay.
So what I would say is an action item.
In the minutes.
Yes. We would like to ask staff to inquire about a sunset provision for current members of the state bar and current certified specialists by the Board of Specialization. Some type of sunset by which they have to transition into the members position.
Right. And logo, because there's a logo for the CBLS and things like that.
And that's important because that is some cost to them. Not everyone do it, but as well, my real concern is it could give rise to an arguable disciplinary action that you're misrepresenting yourself.
So let me go back to this, Lou. So I have two questions. One is, do you have a proposed period for this to sunset?
My guess is that the board already is. My hope is that the board is already having this discussion because it goes obviously farther beyond the specialization program, right? Of people calling themselves a member of the state bar versus being a licensee of the state bar. So
My declaration is not have to change. But
Yeah,
I go to the court and say I'm a member of the state bar and have been for
right.
8 years.
and I think that the judges, because we brought this up, I brought this up at the bankruptcy in a court and about these changes. And I was the only one in the room who was aware of the changes. The judges were like, what? Because the judge's expectation is that a member of the state bar is coming before them. So there needs to be, a few things. There needs to be a lengthy enough sunset provision so that the judiciary as well as the members, the licensees of the bar can transition into it. We need to know what if any, is there going to be some type of disciplinary action for misrepresenting yourself? And what type of public outreach will the bar be? Will the bar have to educate the public and the judiciary of these changes?
Okay. One more thing.
So those are action items.
Okay, so that's what I was going to talk about. So right now, these are proposed changes during an active public comment period. Would you like to incorporate them as a public comment? Because they would be going to Adrian.
I would, as a member of the public, I certainly would like my comments to be reflected.
Yeah, this goes back to our previous conversation, though, is that I think that I'll speak for myself. I believe that we as a sub-entity should have a little bit more weight than the general public in terms of our submitting comment into it, right? Because we are appointed members of a board, right? So I think that as a board, we should be able to somehow contribute our comments outside of the public commenting period, because in that aspect, we are not members of the public right now. We're acting as members of this board.
But we could take public comment from an entity, so you could just formulate your comments now as CBLS. My fear of waiting later or postponing the deadline is it's going back to the board, so.
Right, no, I don't want to postpone the deadline. I think it's just that being treated as not, if Lou goes on and submits something as a public, that's Lou's prerogative, and he's acting as a public individual. When we're doing it, I don't believe we're acting as members of the public. I believe we're acting as a sub-entity of the Bar Association. So I don't necessarily feel it's appropriate for our comments to be lumped in with public comment.
I agree with Rob. I think that there needs to be a comment made from the CBLS.
But I think he's saying otherwise.
No, that's what I'm saying.
Oh, yeah.
I don't want us, I don't think this goes into the public comment pool.
As a
Understanding that Adrian is still the one that's compiling it all, but I think that this should have a different weight to it than the open general public, because we are not acting as the general open public right now. We're acting as a sub-entity of the California State Bar.
Right. But we're also, we're looking out for the best interests of the public, because that's our mission, but as well, we oversee a program of certified specialists and what their interests are.
Well, I think in the case of this most recent comment, we're actually looking at the interests of the state bar, because there's a monetary cost associated with a rebrand, which is what we're talking about, and our attorney members, licensees, because there's a real cost to them as well. So I think we're acting in an actual appropriate area of looking out for everyone's interests that we represent.
In practical terms, I think it basically comes down to we are. Well, it's up to the board of trustees whether or not it wants to value our opinions. Obviously, like well, higher, lower, whatever. But it doesn't strike me as making much sense for us as the Board of Legal Specialization to be limited solely to the public comment period. So we can be included within the public comment period, but we can bring things up outside the public comment period because we're within the umbrella.
Agreed. That's why he's appellate.
Those are the men.
Can I also add something just from other committees who've had like rule changes as well? I've seen in the Board of Trustees meetings that they've had representatives from their group attend and kind of give their comment on behalf of the commission or the group during their public comment period. So they hear it live. It's like limited to a couple of minutes, but you're able to speak on behalf. I've seen that before in the podcast.
Also, something that I just thought of, that like the nomenclature across the state bar probably needs to be modified a bit. Do we still call them admission ceremonies? Do people? I mean, because you can't have an admission ceremony if you're not being admitted. Is it now a licensing ceremony? Versus, I mean, again, these are relatively small things, but
license upon them.
right. I don't. I mean, so we don't. I mean, that would be another thing that like having them across, or does the actual like do the admission ceremonies, do they change in some sort of form, like what the I don't know, that's
That's really important.
In addition to that, is this supposed to be just a semantics issue, a semantics change? Or are there going to be more substantive changes that are envisioned after they make this name change?
I think it's what Lou highlighted earlier. I think it's, the board, the state bar moving from, becoming more of a regulatory agency rather than a trade association. There was that division that happened with sections, and I think this is a part of that. It stems from that distinction for the state bar. But I'm not sure if you want to incorporate that as a comment or a question in this coming from the CBO.
I think we've kind of put together a good round of comments that are meaningful.
Okay.
So do we as a board, going on what Amy said, want to have a representative at the California State Bar at the board meeting to represent our comments?
A chair?
We don't have a chair.
these are
The titular chair.
We don't have. I'm sitting in this seat, and
You fit the seat.
I'm running the meeting. Or do we want to just
Because
let
there's no
our,
money for a new sign.
or do we just want to let our comments go through?
Well, we have nobody local except for Cynthia.
So, where's the next meeting in our main meeting?
Okay.
So is the state bar now considered a trade association?
No.
That's why I have questions.
No. At one time, for almost 100 years, the state bar was a unified bar, both regulatory and trade. Okay, but last year, 2 years ago, it got divided so that all we have now is the state bar purely a regulatory agency. And then the trade side of it got spun off to the California Lawyers Association and all of the sections. So you can be a member of the section, but you can't be a member of the section and a member of the state bar.
Why?
Because you're a licensee.
You're saying going forward.
Yeah. It is
Currently.
not what it is now.
Question then for you, if the meeting is up here and if Cynthia is unable or not willing to participate and we as a board would like to send somebody, is there a budget for us to send somebody up for the next meeting?
Yeah, we have travel money for board members.
Oh. When is it?
May 17, 16, and 17.
How many of us do you want?
How big is the budget? That was the question.
I'd
Anyway,
like to go.
so anyway, I just, you're following up on your point. I think it's good for us to know what our options are.
Well, and I think we need to look at the logistics too. I don't want to derail any plans to do that, to come to the meeting. But also, I think we need to check to see the date and then how this is rolled out. Yeah, so anyways,
Okay.
more logistics to come on that, but
Yeah.
that is an option.
Okay, there's nothing actionable that we need to take today, so it doesn't matter.
Well, but we do
We
want
have
some
2-day
feedback.
meetings, but they don't post their agendas ahead of time, so we don't know what day.
So if we would get travel, we won't be able to do it.
What date is it?
Wait, why don't they have to post their agendas ahead of time? Does
They
it
do.
fall under the?
I
They
mean,
do.
they have 10 days, but I mean, they're like a month and a half out.
No, I understand. So
Oh,
they do the 10 days. It's
Yeah.
not a
I
I
surprise
mean, we just don't
every
know right
meeting.
now. We
Of
still
course,
don't
okay.
know.
I was like, wait a second.
And that's what I was trying to convey too. I was like
Right,
trying
right.
to think too quickly, which day,
Of course, of
all
course.
that.
No,
So
I
we'll
understand
work out
that.
the logistics at a later point.
Understand.
That's the only point we want to make there.
Okay.
But also part of this, the rules changes also includes, I think, another part of the discussion that we wanted to get to, and that is the formation of the ad hoc working groups, as well as, the advisory commission members disbanding and either joining as, again, the ad hoc working group, ledge team member, or also as a grader. And so what we want to bring to this group is that as a discussion topic, suggestions for on the, for example, the requirements for participation in each of these, the composition itself, like for example, should somebody be a certified specialist? Should there be a average experience in as part of the criteria? Do we want people, for example, if you want to be a grader, somebody who's been an author, lecturer, who's been in the specialty for a specific period of time, like 5 years or more? Because we are having a meeting in May, as I mentioned earlier, with the advisory commissions. And what we'd like to do at that time is provide more, an application and more information. We weren't able to do that because, again, we wanted the input from this group here on how the criteria we want to apply for each of those. And so I don't know if we want to start with the ad hoc working groups, or if we'd like to start maybe even with the grading. I'm not sure.
I defer to actually the attorney members on this because this is their grading and whatnot. I have no ability to be a.
Well, maybe we can work backwards. Is there an idea of what does the board have some idea of what the working groups will look like? Or are we just kind of building this out of scratch?
We're building it.
Okay.
You see, our working model is working too well, now we gotta, completely abandon it and come up with something new.
Well, and not entirely. I do want to say one thing. We have talked about and started this year the drafting, team that we had, the paid drafter. So that part has been addressed in terms of creating a ledge team that mirrors the EDGE team. That is an exam development and grading system that looks like the bar exam for legal specialization. So, that's not necessarily starting from scratch. It's modeled after the California bar exam.
Okay, and also we would be not only talking about composition, but scope of the working group's kind of like mission statement.
Yes, and so, again, I want to remind everybody, in our last discussion when we talked about the working group, the idea was not to lose the expertise, and I think the concern was around the certification and recertification process. So one thing the working group will not do is be part of the two-person approval, because, again, if you look at the rules proposals, the rules proposals suggest that that's going to be transferred to staff. So, but what staff will need is that expertise. So it's the purpose of these working groups, again, is to lend that expertise in those complex cases.
Right, and I think that was one of the main questions we had, is when it was said that staff will quote unquote need this expertise. It was still my understanding, and I think it was everybody else's understanding, that staff would have the authority to approve certifications and recertifications without going to the working group. If it seemed from the surface of the application that it was clear that this person met the requirements.
Yes.
It's my understanding. Which that kind of, at least for me, and I think for other people, I'll only speak for myself, raised something of a red flag, because there may be certain aspects of an application for certification or recertification that raise questions, that would only raise questions to somebody that would be a part of this working group as opposed to staff. It might be something that jumps out about a particular case, or how something is being credited. There's just, for instance, or something within one of the recommendations. It's hard to even speculate. I've seen a million different problems with a million different applications, and it's you kind of know it when you see it. Mm-hmm. So what my initial concern would be is that there should be some level of eyeballs put on essentially every application by some member of a working group, whether it is staff identifying a certain group of applications that say, look, we don't see any problems with these, and we're ready to certify these, and those could perhaps have a more, not cursory, but a less kind of strenuous sort of review, as opposed to others that the staff would on their own say, like, look, we really need to have the working group look at this for more serious problems or discrepancies.
Going along the lines of what was just said, so what is the criteria, if any, that's been discussed or written out of what would trigger that it needs to go to the working group? Is it literally you're sitting, not you personally, a person is sitting and reviewing and go, not sure? Or can the rule be as proposed?
They would have no idea. They can look at what perfectly appears as an application meeting all of the requirements, and unless they practice in our area,
right,
you wouldn't know that recommendation from a certain person. We know they don't even know what they're talking about, and it's not readily apparent from that recommendation. They wouldn't know because they don't practice in the area what that particular licensee may have as issues that are out there that are under the surface, because they don't practice it, so they don't know that the local judge has stripped her of her practice and put in somebody to take over that because she was stealing from the client trust account. Right. And so only because there was local knowledge by practitioners that it got to the board that we were able to then get additional references from people in the know, who we got stacks of them that says you cannot recertify this person, it would be an abomination, here's all the pieces, and we were able to stop that. Mm-hmm. There's no way staff is completely competent to take a look at that, right, but they wouldn't know that. They don't practice in our area. That's the piece that the specialists here add to it, that it can't be replicated anywhere else.
Right. Yeah, like we had a situation on the bankruptcy side where there was an attorney and we knew about I don't know, at least half a dozen malpractice claims, which you would never know about. Or you wouldn't know about the fact that the judge would not allow this lawyer to appear by phone, that they had to appear in person every time. You don't know those things.
So has the Board of Trustees addressed this at all in terms of?
Well, we told the consultant this when he came here.
Right.
I don't think any of those concerns showed up in his report.
I mean, I think they're valid concerns. Again, as a public member, I think they're valid concerns, and it's not an insult to staff. But even, you know,
No, it's not staff.
Staff is doing everything they possibly can, they're doing it
Oh,
right.
yeah.
It's the reality.
I think it's legitimate, and I think that the Board of Trustees needs to at least address how it's going to handle this before going into creating it, because I think it's a real concern from a public safety perspective, which is the public interest perspective, as well as from the other attorneys who are specialists not watering the program down.
This is the difference between specialization and admission.
Right.
So if we're gonna have a specialization program, you have to keep the specialists involved in it.
Right. So that's what we talked about, that bar admission, you're asking for the keys to the front door. And that's all you get. So you have 300,000 some odd licensees basically been allowed inside the house. But you have 5,000 who've been invited into a different part of the house. And they only get to be there if they have gone through the vetting and scrutiny that the California Supreme Court wanted the specialist program to be set up and handled. And they don't get to always be in that part of the house. Every 5 years, they're going to get reviewed again. That's very different than being admitted to the bar.
Yeah, and I understand that we don't answer to the Board of Trustees in any way, shape, or form. However, I think that, again, representing the program, if this is the direction that is going to be moved in, it would be nice for them to at least acknowledge that there is a concern here and how it's going to be addressed.
Well, but also, we also have an opportunity to create a protocol, you know, because I think
We have a protocol in place, though, that's being thrown out.
Right.
Yeah, so to reestablish that, I mean, I
Right.
think from a staff perspective, we don't disagree that this perspective is critical. I mean, we're convinced. I think at this point is just, what is that remedy?
But if we propose what exists, that gets thrown out because we already
It
know that.
does.
I have a
It does.
suggestion. I have a suggestion. One, I don't know how everybody feels, but I think working groups for each specialization should be at least 5. I think it should be at least 5
members.
5 certified specialists in that.
Any kind of look from various parts of the state.
Hopefully, that's the thing. I think
That was always the key.
yeah, having geographic diversity.
Right.
But like having the proposed structure, I don't think is fatal in the sense that like just having staff approve or disapprove certs or research. What I would propose is that staff goes through, does the initial review, and divides the applications into two things. One, we don't see a problem with these. We think these meet all the certifications. And another, here are some with problems and have problem areas. But all of those applications go to the working groups with some kind of, 2-week working group comment period or something along those lines. So like all of these applications are brought to them. Like the majority, hopefully, knock on wood, would be ones like staff doesn't see that there's a problem, but the working groups still have, say, 2 weeks. Everybody can look at them and see, well, maybe there is a problem. And the other ones that are diagnosed already with having a problem, obviously at that point the working group would do a more in-depth sort of review. What I think that would do, that would help solve like what is being proposed and like kind of meshing it with some of our concerns, which is that it would still be staff approved, like basically approving things, but what it would do is have every application have eyeballs on it from the working groups. And obviously the working groups, the staff, look, I mean, staff, I not only do I, like, staff's actually, like, been so good at flagging problems in applications. Because I say sometimes we spot problems that staff wouldn't spot. I'll admit, sometimes staff spotted something, like, you know, like one of the requirements that like, oh man, I might have let that slip through the cracks. So, and it just bring it up to the working groups, like, look, please have any questions or concerns to staff within Y period of time
Right.
as to any of these. And then after that, staff can just go ahead, approve, not approve, or go back to the working groups. But I think every single application should be brought to those working groups.
And that really is a public protection safeguard.
So I want to go back to this. Okay, so and I'm just talking about order of this process. So we would get the applications, and you're suggesting that after the two staff review, it goes back to the working group. Because my only thought is it now creates a third person, a third party review. Not a third party, but a third review. And maybe that's not a problem. But remember, it also comes back to this group, which I recognize is getting smaller, has less representation in specialty areas, and this group has counted on the advisory commission. So maybe that doesn't, and that's not going to dissolve. We're still going to bring that full list here. But my only concern is what you suggested right now was that the advisory commission this working group look at it, and then it comes back to the staff. Like, I mean, are you suggesting that
I think
initially
staff
goes?
looks over it first.
Okay.
Because what's been proposed, from what I understand, is there were going to be some applications that never got to the working groups.
Mhm.
That staff was going to be like, look, all the I's are dotted, all the T's are crossed. I have the recommendations. I have all the points there. Like, I would check, like, all the check boxes have been met, and so those were just going to be approved. And then there were going to be other problem ones that went to the working groups. What my suggestion is that initial review happened. Every single one of those applications goes to the working groups, divided into those two categories. So staff's already done the hard work, the spade work of like going in and like seeing all things, but there can still be that public protection purpose of having, it's like, look, here are the working groups. We've checked these off. Obviously, these are subject to, these may have problems that we can't see as not specialists, and the specialists would look over those. And in addition, you'd have, for lack of a better term, the quarantine ones that might have some issues that the working groups would really focus in like a laser beam on, because those would be the ones already flagged by the staff to have concerns that they can't address.
Mm-hmm.
But this way, the public could be satisfied. The public could be satisfied that every single application to be a specialist is being in some way reviewed by a group of specialists in that area, while at the same time having the efficiency of having staff go through, really flag the ones that like, look, we think these are fine. We think these all meet. You folks, if you can just take a pass at these, and if, a 5-member working group takes a pass at them and thinks it's fine, then so be it. Comes to this board, approved, next.
Okay.
So that's my.
Okay.
Yeah, I like that.
So another question I had also, and I know each of these applications have their own maybe like detail or specification that might vary from one specialty to another, but also in combination with this review process or revised review process that incorporates a working group looking at every single certain research. The other thing is, what about the application itself? I think, Lou, an example, and I think, Mark, you had an example of where it was input from a judge or input from somebody's, I think you had an example, I think it was a tech filing in your example of a potential violation.
Oh, yeah, so that was that application that we reviewed a couple of meetings ago, where someone was trying to be either certified, recertified, and they didn't have all the experience necessary. There was second chair.
Yes, no, we talked
Remember
about
that one?
we talked about
The whole second chair
Yeah.
thing?
Oh, yeah.
That came up with Roy.
So, I'm just suggesting, is there something substantively that we could add to the application that might highlight or at least convey some of that, or potentially help us dig it up? I mean,
I'm not suggesting that we need to have a background check on every single individual.
Right.
But something that is maybe lacking in the current version of these applications that can help address some of that or begin to flag some of
Well,
that.
for example, I know there's a disclosure of that if you have had any state bar complaints against you, and that's already in there, okay? If you have had any sanctions, that's already in there. I don't think there's anything in there about if there's any pending malpractice actions against you.
Okay.
I don't think that's on the application. Is it, Kristen?
So our applications are actually connected to the standards, and I wanted to piggyback on what Amy was saying. Our standards haven't been revised in a very long time, so I think this would be the opportunity, possibly of the function of the ad hoc working group, to revise them so that they reflect more standard things or like reflect novel things that come up in the application process that should be disclosed. So it's not like we're just basing it off the subject matter expertise, but it's a little bit more solidified and more formal. That could be another function of the ad hoc.
Like I just saw something come up on the bar's Facebook page that, so far as a result of the fingerprinting, 2,200 licensees have been flagged as having outstanding convictions, right? So I think the standards, I think that information that comes off of the fingerprinting should be part of the application process.
Yeah, and that's definitely something that working group could present to the CBLS or CBLS and say, can we refer to the ad hoc working group to do more research because those are your specialists in that subject area. And that's potentially a function in order to kind of formulating ideas.
I mean, to the original point, if I understand it correctly, I don't know if there's anything that can be added to these applications that will make them less subject to trying to be, trying to get an exception or something along those lines. It's like, after all, we have these are lawyers applying for these things, so they're always going to look for an exception. I mean, I thought the application process was fairly clear cut. I don't know about everybody else. But.
Well, I guess what I'm trying to do is, in Lou's suggestion about looking at malpractice, complaints or violations, that's just something more subjective. And I'm not suggesting that this entire process is subjective. But given that we're going from a group of 11 members down to 5, there's a chance that somebody's local reputation, there isn't anybody that knows somebody's or that understands, somebody's background or has worked with this person as a colleague or in the same court. So my other thought is that other catch-all is to go back and look at the application process, and is there other portions that we can add that might, help in the process, in the vetting process.
I mean, I hope this doesn't come out the wrong way. Like I'm not necessarily resigned to, but I think I recognize. I think other people can recognize that the commissions, what used to be the commissions, there will not be nearly as robust a level of review with what comes out. And so with these working groups, and okay, taking that as it is, then so be it. I mean, I think, and I think, Amy, what you're trying to point out is actually, I appreciate you asking for that. I don't think there's any way we can do that in the application. I think in the end, we're going to have fewer eyeballs. It may be on a more compressed time frame and stuff. And frankly, I think that's an allowance that we are going to have to make given this restructuring. But what I was proposing is at the very least, and what for me would be the base level, is to at least allow some period of time, be it a 2-week working group comment period or whatever we want to call it, for every application to be up and available to the members of these working groups who are certified specialists in these areas, such that concerns can be raised about any application.
And we're, just to be clear, I'm not suggesting that we shouldn't go.
No. In fact, you're suggesting something else, something further.
Adding something,
And I would say I appreciate that suggestion, but frankly, I don't see what else we could do. I mean, we're not gonna, it would be akin to asking people on their applications, like, okay, is there something more we
There's
should
somebody
know?
who
Is there-
doesn't like you, we should talk to.
Right, is there dirty laundry that like you want us to bring on in this app? I mean, realistically, I don't think that there's something to add. I think that the working group review such how I suggested it would really be like that level of that. And there might be things that don't get caught with this process.
And the piece that I would add to it, I agree, I think you've gotta have 5, I think it gives you the opportunity
Yeah.
for greater geographical diversity makeup in there. One of the things that was very powerful in those file reviews was when we got together as a group and could chat about some of those issues among the group. So if you're doing a working group review, it ought to be all together telephonically, whatever you do, so that everybody can kind of, take a look at them and ask questions. That's how things got uncovered.
Yeah, and I'll add that during my time on the BLAC, there were applications that came up of people that I knew for years and was not aware of some of the issues that they had. And because of how tight-knit the bankruptcy community is, there was almost an intervention that took place that was critical. Hey, you really gotta get your act together. You're not gonna get certified. And that's a function that no consultant could ever have appreciated. And that's important because just like the state bar wrestles with abuse, substance abuse and things like that, here were a bunch of professionals who actually intervened on a colleague's ways, and some of the judges got involved, and it made a difference. Never would have happened.
And for me, I just want to clarify something like kind of a meta idea from this. I take it, right, nothing in my comments was to suggest that the working groups would have veto power over anything. I mean, I think that recognizing this restructuring, I don't believe there's a role for the working groups to essentially be voting on these. It would ultimately be still the staff's recommendation, but what would happen at the very least is there would be a period by which the working groups could look at it, could present concerns to staff, but in the end, the staff would be making these determinations. I mean, that's what I took from these proposed rules. That there's no real idea that the working groups are essentially going to be smaller advisory commissions, such that they're going to be voting on these things. So and if that's the way it's going to be, that's the way it's going to be. But if that level of base review for all applications is taken care of, in an ideal world, I'd rather have just the advisory commissions just exist as they were, but that's not going to happen. So.
Yeah, I agree. From a public perspective, I think ultimately we recognize that it's staff is going to be the one that's making the decision, the approval, or to pass it on or not. But I love the idea of the peer review. I think it's extremely important based on what I've seen in the last 2 years of being here, and that I think that's a really great proposal that was just presented. That is basically acts as a peer review, for staff, right? To be able to have one extra step in the vetting process that recommends back to staff, hey, you may want to look into this more or not, but this is what we think. And I think that is a really good compromise in my opinion. So what is our procedures for getting this? This is where I always get stuck and we always kind of get hung up because and again, it's no offense on anybody, but I feel like sometimes these comments die here. And I want to make sure that these comments make it to the Board of Trustees because I think that this is a really good recommendation.
Well, I think this is why we thought this agenda item would be lengthy. I think it's important to go back, if we're submitting comments, if the CPLS is submitting comments to Adrian, that we list them. So the first comment that we had, I think we're all in agreement, and this was related to the licensee and membership issues, and those got addressed. I think the next comment then is perhaps the proposal made by Roy that we need 5 working group members minimally by specialty with geographic diversity. That we also, knowing that they don't have.
I want to let Adrian get caught up because I think he's going to type this out. So.
Oh, you are? Okay.
Sorry, I didn't mean to cut you off,
Oh,
but
yeah.
I don't know, I want to make sure that he has the opportunity to catch up.
And do you also want to include, in terms of standards for advisory commissions, practice length, like their time in the practice area, or just varied in terms of like new specialists, older specialists, while we're talking about?
Well,
So what I already had was for, oops. That's vision for attorneys to transition to. Did I miss anything else?
Enforcement, right? Enforcement of
Yeah.
what happens if somebody's out of spec, if you will. Enforcement of non-compliant licensees.
nomenclature.
How does it affect discipline? And then also, is there a goal for public outreach to educate the public on the changes?
Including the judiciary.
It's not public outreach, it's
It's
industry.
very important that the judiciary understands.
I'm sorry, go for.
Public outreach.
Public and professional outreach.
'Cause I mean, I can just imagine going before, District Court Judge Manuel Real in the Central District. And he sanctions me because I'm referring to myself as a licensee. And I can just imagine.
You do it too in a
Oh
heartbeat.
my God, I mean, I've been in this courtroom, I've been the recipient of that. And the district court judges especially can be very harsh. And I really do think that the Board of Trustees, before they actually absolutely make this decision, they reach out to the judiciary. Because ultimately, the judiciary is the one who has the lawyers coming before it. And maybe the judiciary doesn't want to hear from licensees. They want to hear from members of the bar. I think it's a mistake if you don't go to the California Supreme Court and the AOC and ask them.
And also the comments on the first one, to get the nomenclature consistent throughout the bar. Like the classic example would be like admission ceremonies, and where we not referring to admissions while we're no longer members.
Right,
Well,
so you don't
so-
have, right? Your AIMS program, what does that stand for?
Admissions.
But you're not admitting anybody.
Well, that's what I wanted to get to. If you look at the committee, the admissions rules revisions, because they went through a rules revision and had the licensee, the change from member to licensee. We still have admission ceremonies because the idea is we still need an admissions date when somebody was admitted as a licensee here at the state bar.
Permitted as a licensee.
I think your license
Issuance
is,
date.
yeah, it's an issuance.
Isn't it an issuance date? Isn't it an issuance ceremony? You're issued licenses.
But the bottom line is we still need a swearing-in ceremony. That oath is part of that process. I mean, we would have to
But you
change
take
the
an oath as a
entire,
member.
we'd have to re-engineer that process.
Can I ask a really stupid
Why
question?
change it?
Why are they doing this?
Yeah, how was, we're gonna be,
What's
what was the tipping point that said we need to change from member to licensee?
Why is it so important?
It was that shift.
But
you know.
Why?
Which shift?
Why
though,
do
again?
they have to change the nomenclature from member to licensee?
Oh, the shift from regular, from,
Two regulatory.
to regulatory.
Oh, it is regulatory.
Regulatory agents.
Member can be regulatory.
You regulate your membership.
You regulate
Like,
your membership.
okay, attorneys who are admitted to practice in Colorado are members of the Colorado Bar. All the educational stuff is not done by the bar. It's done by another organization.
I have that in Connecticut too.
I'm gonna.
I
tell
agree,
you-
that having been said, this isn't the hill that I'm gonna die on. I mean, I think, I really, this is.
Well, you have all great ones today, I would use that one too.
I think this is probably like,
Let's say in Colorado, okay? The Colorado State Bar is a non-governmental organization that runs CLEs and so on. Every lawyer has to be admitted to practice by the Supreme Court. No one's required to belong to the Bar Association, but they are called members. they've been admitted by the Supreme Court.
So for example, I have a case in Nevada and I'm doing a Pro Hack Leach application. They ask me where else am I a member? So now you have every other state. Okay, every other state refers to their attorneys as members of the state bar. Every other state and court has these references to you being a member of your bar system, of your state bar. I know California likes to be different, but the economic effect and the perception and the courts and other jurisdictions, it goes beyond.
Well, if you can't answer that question by saying you're a member, they may not let you appear.
Well, I can't answer the question.
Right, that's my point. So what are you gonna say? Does it even give you an option to say, no, I'm a licensee?
Well, you're a member of the group of attorneys that are licensees of the State Bar of California. So, I mean, you just ask, I mean, but it's silly.
But you
No,
see
that's
where
not
this
the
goes?
question.
Amy, you see where this goes?
Yes.
It's a never-ending issue.
I like that. This is not the hill I'm going to die on. So I think we're kind of
No, it is the hill's gonna die on.
yeah. Well, yes, but I think that we've stated it over and over again, and so the just we're putting it into the minutes that will then be public record and sent up to the board of trustees because I think it is important that this message get passed to them on behalf of this board.
Okay.
Also, depending on facts.
And I would just, by the way, thank you. I mean, put this together like kind of immediately. That's very impressive. I would say staff separates into 3 groups, the third being incomplete. And then groups 1 and 2 are given to the working groups. While group 3, staff just kind of tells people what your application is. I mean, again.
Spoken like an attorney.
Yeah.
Agent, we're gonna put about Lloyd dying on this hill.
Not
dying on this
Let
hill.
the minutes reflect.
We're
that
not
we will
dying.
not
You're gonna have
die
a
on
gift
this
file.
hill.
You're gonna have a gift
This
file.
is the hill I'll die on.
No, he said this is not the hill.
This
I
is
will
not
die
the
on.
hill. That's what he said.
The other one. I haven't decided whether I'll die on this. That's it. Previous hill. Okay, but that actually, yeah, that's exactly
Perfect.
Okay.
Just a question about the minimum number of the volunteers. My initial thought is there admiralty specialty area? I think finding 5 volunteers would be very difficult, given that we get about 1 to 2 volunteers.
5 for every specialization except for admiralty. That could be 3.
And trucking.
Well, and trucking.
Because there's only one person, and he's going to certify himself.
Or he might
Well,
not want to be certified.
I don't.
Oh, I should not have done that because I just derailed us. I'm so sorry.
No, I don't.
And
Well, what if he
I'm
doesn't want to be
so
certified?
confused.
Should we say maximum?
Maximum of 5.
Yeah.
Should have maximum.
Or do you want to?
For one
Do
more.
you want to call it admiralty specifically?
I don't know. I mean, it's. But no, it's going to be hard to get.
Admiralty has
5.
how many?
We don't even
24?
have 5 on the district currently, so it's hard to recruit, obviously, because it's a small pool to draw from. And they would be, I think, reviewing their own applications in
Right.
a lot of instances, so.
Well, okay. The goal is to get 5.
5 when practicable.
Yes, 5 when practical. Practicable.
Practicable.
Or when practical.
Practicable.
Okay. Okay. So I think we got the working group. Anything else related to the working group?
What happens to the nomenclature? Oh, that's what's such a well, okay, but then we kind of followed up. We said that there's all of these other instances where you're going to have confusion in other jurisdictions between now the California lawyers being referred to as licensee rather than a member of the bar. So what we want is greater thought being given to beyond California, where you've got lawyers in where California lawyers are going other places. Like in the bankruptcy context, you've got lawyers going to Delaware all the time. What are they going to tell the Delaware court?
I'd like to rephrase that though. I think when you say greater thought, it's coming in from a very aggressive standpoint. And it's,
I apologize.
so rather than say, can you give greater thought to this, I think it just needs to be addressed as how this is going to have impact on California attorneys outside California.
For
Yes.
consistency purposes
Bad choice
across
of
the
words.
country.
Yeah, consistency throughout
Across the country.
across the country.
I mean, licensed to practice law by the State Bar of California doesn't sound too bad.
License to practice is
License to
not
practice is different.
than being a licensee of an organization. When everybody says licensee, I'm going to tell you what I think of. I think of when I worked at Disney, and the licensees were the people that had permission to go and make toys and put Mickey Mouse on it, right? So that didn't imply anything other than they paid us at Disney
For the right.
for the right to do something. It did not say anything about the quality of product or that they had anything. And so it has a different connotation in the public. So
Okay.
we got rid of greater thought, by the way. No,
Or how about
we don't take up
how about
greater thought.
consideration?
That was a,
Further
that was
consideration.
poor use of words.
I don't think we should go more detailed than this.
No, perfect.
Yeah.
I think it's good.
Yeah.
All right.
Yeah.
Okay, go.
All right, so now we got the working group.
I knew this was that. I'm glad we broke for lunch. Okay.
Okay,
We go on to exam development and grading, yes?
Okay, so when someone writes an exam question, and I did it for free.
He's not bitter.
Party of one? Or party of two? Party of two.
Seinfeld party of one. When you did a question, you also had to write the answer. Is that still the case?
All of the questions have model answers and the answer teachers and some legal citations.
Yeah, see, when we did the exams as a group, they were structured. We put an exam together.
Right.
Right. We actually sat down. It was kind of cool. We
We
sat
can do
down
that in names, so.
Yeah,
and we
we're
put the
doing-
exam together. Okay, from easy to hard. So that when someone took the exam, you were able to kind of test that range. Is that still going to be the case? Okay, that's good. And who's putting that together?
I mean, I'll give the update too, if I can share that. Is for 2019, the advisory commissions are kind of finishing their process because
Okay.
they've drafted it. They're going to see it through and complete this exam.
Okay.
Moving forward, we'll probably be members of the ledge team.
They'll assemble the questions.
But who has the final say into how the exam is balanced? How many questions from how many different subsets of the specialization, stuff like that? Who does that?
Yes, and currently with the Edge team, that there's an Edge team leader who kind of, I think they facilitate a conversation with other attorneys to figure out the spread of the exam. So I think we would try to mimic that structure for legal specialization. So you'd have a leader, but they would talk to subject matter experts who have got the experience to figure out the allocation.
The allocation and everything. But now, is there an idea to get the working groups involved, and where would the working groups get involved?
Working groups would be separated from exam
So the
development.
working groups wouldn't. Okay, so the working groups are only talking about applications.
Yes.
Okay.
So how is it that an EDGE group draws upon the particular issues and a specialty to assemble an exam?
Yeah, so we have the exam specifications, which they're noted and they're very consistent every year, that have the different subject areas, like subject area 1 through 8. I think that would be a basis, and then also getting feedback from members of the ledge team. I think it'd be very similar to what the advisory commissions do, but titles and
The
names would be
ledge team
different.
does not consist
What's
of.
EDGE or ledge stand for?
Legal specialist, examination, development, and grading team.
And does that consist of various certified specialists?
I mean, we'll discuss that today, but that was the thought, and possibly people who have been members of the EDGE team, in which they do the California bar exam and the first year law students exam, because they kind of have institutional knowledge that we can draw from when transferring over to this new structure.
So, and I'll just keep drawing upon my experience on the BLIC. there would be attention paid in some years to particular issues in bankruptcy that we wanted to test because they were hot topics. A recent Supreme Court case, more types of issues coming through that we wanted to make sure that people understood, that were on the front burner of the courts. I'm sure that if Donald were here, he would say the same thing about immigration.
Same here for estate planning and portability
Right.
and things like that.
So when these exams are put together, it was that collective knowledge of the commissioners that knew what we were, some of the topics that were to be tested because these were topics of importance. And there's no computer program that could ever give you that artificial intelligence.
Well, that's another thing. So I want to clarify, because we had to do this for the advisory commissions. We're not suggesting a computer is going to take over this task.
Right.
I mean, we're hoping that the group that's developing the exam right now, advisory commission members, that we
Come up with a criteria to
pull like the strongest members of that team that want to get paid to do this to become
part of the exam development team.
or members for this, or even graders. So I think more than anything, what we're asking, and so that would not
Lose this issue on the hot topics or current relevant law in these specialty areas. And so if anything, what we're seeking is a little more input on criteria that we may apply to differentiate between those that have the strength for exam development or strength for grading, the input that we're seeking today.
So the people who are on this, it's called ledge or edge?
Ledge.
Ledge.
The legal.
Are those paid positions?
Yes.
And what's the budget for that?
We have to pull it out. Do you remember how much we put in? It's in the budget right now. That it was attached to our agenda. But again, we probably shouldn't address that right now because I think it's in closed agenda, right? Oh no, that's next.
Okay.
Okay,
So I think one of our collective concerns is that there be a vehicle by which the exams can continue to be the manner by which prospective specialists know or they're tested on the most current areas of the law and important changing areas of the law.
well, and I guess, for me, what I'm hearing then is like, perhaps you'd want a member of that drafting team then to have experience or be currently in that field. Could that be a criteria that we add?
See, and now you can see better the difference between this exam process and the bar exam process.
Okay, you do that. What do you mean by that?
Well, because the bar exam process, you don't care about current areas of the law. Do you know the black letter law? But in this area, but when you're dealing with specialists, it's can someone actually sit there and counsel a client in a particular specialty without committing malpractice?
And to take off on that, I can only speak for appellate, but there are certain, like the balancing of the exam is, it's a really kind of delicate thing because there are certain things that are far more amenable to multiple choice questions than there are to essay questions. If the exam, for instance, we have X number of essays, so we have to balance that. I won't say that's actually like the wrong way of testing appellate law because there's certain things that are like kind of black letter things that don't really lend themselves to like the weighing that you'd see in like a typical essay versus like standard review stuff, that sort of stuff. So again, like I think that a final, I mean, again, I know the working groups aren't gonna be here, but like the number of people that are involved in drafting each exam, again, if there's like a not only in the compilation period of the exam, but also in the review of the final product, of like going to them and just saying, okay, look, like, evaluate it for balance within the essays, balance within the multiple choice. Is this a fair representation? Does this fairly test
subject area 1, subject area 2, subject area 3, because I know like each specialization is cut into different,
Specs, yeah.
you know, specs. And then it should go back for further rebalancing from there. Because we had a devil of a time doing it as an advisory commission. We had a lot of people in on that. So.
And I wanted to bring up too, we do have some additional resources, so there wouldn't necessarily be any additional drafting because we did have that drafting program where we just have, you know, a surplus of questions. But of course, if the question doesn't cover a hot topic, you know, subject that comes up that year, I know that happens sometimes, we probably do some additional drafting. But in addition, I have like research from like the past like 2 exam cycles that has feedback from the advisory commissions giving their allocations for like what percentage should go where and things like that. So we wouldn't be starting from scratch. I think it'd just be refining it every like exam development cycle.
Remember though that your bank of questions age out because the law changes.
Mm-hmm. We wouldn't just be pulling them and using them. I think there'd be editing, of course, but we have a base, which I think is also really important because.
Okay.
I think it is.
Do we have any
That's good.
that we wanted feedback on?
Well, I believe that was it for section F, so, for graders.
Oh,
Yeah, for graders. So I want to put up a criteria that we use for the bar, for the California bar exam. To be a grader, we usually, you have to have passed the bar exam within the first two attempts or the first attempt. Crystal, do you remember? Oh, no, but anyhow, so we can establish that type of criteria, like somebody has to have had, and this is just a suggestion.
Excuse me, thank you.
If you, if we want to establish that kind of a criteria, that's just a question we want to put out there. To ensure that we, you know, just, that we have a skill set tied to, or requirement tied for somebody to be a grader.
I think it's best to pull upon the dozens of past commissioners, because they understand the exam process. Right.
Well, given that not every commissioner can become a grader, you know, it's going to be a smaller pool of folks.
No, but you have, over the years, how many have you had? It's been going on for 37 years. You must have.
We age out at some point along the way. Right.
Speak for yourself.
Okay. Well, but are you suggesting then that tenure on the advisory commission should
Well,
be
I
a
think
consideration?
you should go back and ask prior commissioners first, because they have the most knowledge about the process.
Okay.
And then I think another like related question would just, I don't know if it'd be more appropriate for a grader or for like an exam developer being part of that ledge team, or, you know, professors or people who are not necessarily certified specialists, but they have a very, they have a wealth of knowledge it can bring, especially for writing questions or grading them, and they have similar experiences. I don't know if that would be like reasonable to include them or not for the specialist exam.
I would actually like actively not want professors.
I would agree.
Oh, absolutely.
Okay.
You know, professors sometimes think academic
Now,
data.
adjunct professors who are practicing attorneys who, you know, go and teach part-time at a school, I don't have a problem with them. They're practitioners.
Right.
This is a exam written for practitioners.
Mm-hmm.
And then just, should being a certified specialist be a requirement or just?
Yes.
Yeah, yes.
I'm just thinking, I just know a handful of attorneys who they didn't pursue the certification for several reasons, but they're very smart in what they do and they're well renowned in their field. Would there be a special cause for justification if they wanted to?
Must be a specialist absent exceptional circumstances.
Right.
Something like that.
Marshall Oldman wants to grade stuff, you let him grade stuff. He knows his stuff in and inside and out, is respected throughout the state as trusted states. He purposely did not take the specialization.
Yeah.
So, you know, somebody like that, yeah, that's fine.
I like how Roy phrased it.
Absent exceptional circumstances.
Comma, absent.
Something like that.
So,
Okay. All right.
Qualifications.
special circumstances?
Absent exceptional qualifications, because it's not.
Or along, but And I would add to specialist or former specialist.
For those retired.
Yeah.
Yeah.
There's a lot of people that just like they're not practicing in the area of law that like and they don't have the points, so they don't recertify, but they probably know they know the practice backwards and forwards.
It's gonna be current or as opposed to of, but that's
Yeah.
okay.
Oh,
Must be current or former specialist, absent exceptional qualifications.
We'll take that. We'll take that.
Okay.
Okay,
All right.
all right.
That gets us actually through F onto G, which is the update on the 2019 Legal Specialization Program budget.
All right. So, Business and Profession Code 6140.1 requires that the state bar submit an adopted final budget to the legislature by February 28th.
Who did that go to, by the way, legislature?
Who does that go to in the legislature? I know we have a legislative contact. You want somebody's name?
Well, is it some type of, is it the Business and Professions Committee of the Senate? I mean, who does it actually go to?
I would have to research the answer to that.
If you could, please.
Okay.
Action item.
Now, what we've attached to the agenda item is the budget that was submitted for legal specialization. And, and that includes the $1 million loan that we talked about made to admissions with the first 3 payments incorporated. And just as overall broad statements about the 2019 budget, expenses are lower, anticipated lower for 2019. The initial pilot drafting program ended in 2018, so it's not reflected in this budget. And again, the last part I want to highlight is that the board's going to be taking over the financial reviews of the budget. So with that, does anybody have any questions, concerns, or comments?
Luke?
Why is it projected that we are going to operate that it is the deficit for 2019? What is it that has changed?
So in 2018, we didn't have an examination cycle.
Correct.
So I believe that causes us to have more expenditures in 2019. Are there other items, Adrian, that are part of that consideration?
I think the cost of the exam for 2019 because your contract with the facilities, things like that. I don't know if we'll get the same results in terms of who registers for the exam, but I think we'll always use a little bit money because there's housing accommodations costs and the larger facilities that we contracted this year.
So on page 2, revenues, exam fees are going up because the exam's coming up, right?
And it's also an increased rate because the 2017 was $100, so it's technically for the 2019 exam.
Okay. And then other revenue, what's that? Those are just the specialist fees?
We have those, and then you also get education provider fees. That's a minimal amount. I think they get kind of clumped in that line item.
Okay. And then the personnel expenses. So how many state bar personnel are actually assigned to the specialist program? 1, 2. Who else?
No.
We have 4 currently, 5 at full capacity.
Okay. And is that what that number is there, the 556, 500?
On the first page.
I
I would say that, yeah, we did.
That's that, right?
Yeah.
And then leases and rent.
I know part of it, I think, it's budget rental, part of it is
Interfund.
Unifund, but also,
Well, inflow is a different part. It's a different line item.
I'm sorry, where is this?
Expenses, leases and rent.
106. It's under the
Okay.
556.
Is that the exam location? For the-
That is part of it.
But at the top is examinations.
Which,
Let's get into it. Okay, so, all right, leases and rent what that is. Services, supplies and equipment, other expenses, what are these? How do these break out? Indirect costs,
So supplies and equipment are kind of straightforward. I mean, we've had to get laptops, especially for transitioning into this AIM system.
that's what I'm saying.
Yes.
We spent $120,000 per staff on equipment, on computers, on laptops? I don't think so.
Wait, what page are you on?
Foundation also includes postage, I believe,
Well-
too. Results
Not
letters.
$500,000.
For supplies?
Yeah. Yeah, how do you justify $500,000 of programming for staff members?
Well, and let me just say this, if, we should look at the operating statement also that we added, because this is what's been budgeted, whether we use all of it or not is, I think, another question. So, that is, part of the tracking, so.
But in 2017 actual, okay, I see what you're saying.
So if you look, in 2017, we used 92,900. We allocated for 2019 supplies and equipment 480,000. Whether we use all of that or not is.
But didn't you have 4 employees then who all had laptops? You don't buy new laptops for them every year, right?
No, we didn't, not every employee has a laptop. With the AIMS process, I think the idea was to get everybody to capacity. Like these laptops here do not belong to legal specialization.
I think that we can continue to ask on every single line item, but the answer is, we don't know the answer to it. So I think what we need to know is what falls up into each one of these categories.
Well,
I'd
and the way
like
you
to
could do
know-
that is roll it up to, if you look at the operating statements,
that's
right? So we could roll it up that way.
supplies and equipment include stationery, telephones at the exam sites, computer software purchases, computer supplies.
Is Ames in software purchase? Is
Yeah,
Ames
Ames would
in
be-
the software purchase? That would be under supplies and equipment, and you guys are amortizing it across years?
I would say so.
That would make the only.
That would make a lot more
That would make the only thing that would take it from 92 to 891.
The operating statement is with the budget and not.
I think we would like to see is what do these items consist of? Because, for example, in 2018, 2019, supplies and equipment was almost $1.2 million.
Well, that's easy to do. If you take, what you have right here is by cost center. What you have in the operating statement just rolls across. So I think that what Rob's doing right now.
I'm trying to.
So one is a summary of like personnel expenses. You will have things like, for example, overtime plus staff time, salaries. What you'll have for example, leases and rent, or let's go to supplies and equipment because it's got more categories. They're all rolled into the operating statement. So the
Yes,
operating
yeah.
statement has it all fleshed
What
out.
you gotta do is click on these things and it opens up into a separate spreadsheet so you can see like those items.
Okay.
You're not having to do this. I think as a number, I saw $15,000 in ride share expenses. That's a lot of Uber.
Well, I think it's not Uber, right? So we don't pay for people's to do Uber or Lyft. What it is the supplement that we have for staff, to use, BART or the train system. Like it's a commute program.
Okay.
Yeah, that's what
So
it refers to.
if I can interject, so it looks like, again, I'm eyeballing this, supplies and equipment, if you go back to the earlier reference, right? The 41,000s in terms of what the line items are, it looks like these are what fall into supplies and equipment. And included in there is a computer software purchase.
Mhm.
So that 700 for 2018 annual budget was $755,000 of the 2018 annual budget, right? So,
That's it.
okay.
Mhm.
And then but here's the problem though. That also should have been in 2017's budget, okay? Oh, budget, but the actual was only 40,000. So yes, so I understand
Well,
exactly.
and I can explain that too, and maybe Natalie did when she was on here, but there was money that was put away for that item that we keep talking about, and that is the, the item banking solution, which we have not bought. So we put it in the budget, and there's a chance we may not use it, and we believe that that costs something like 480,000. So that's been allocated. It may not get used, and that's exactly what happened in 2017. It happened in 2018. So my suggestion is, if you want to, dig into this deeper, I think you do the exercise that Rob's doing now, which is digging into the operating statement in conjunction with this, and it'll give you. By looking at December, you get the full year that's represented here. You get what's allocated, and then as well as what is the actual. So, and you get to see the expense pattern, because the operating statement also includes a previous year. So you'll have 2018 and 17, which should correlate with this. Okay.
I mean, I can do the math, but yes, I do believe we can figure out how to roll it up for these two documents.
Okay. So, and again, this is 2019, what's been allocated, and again, it's going to, there will be a difference between the allocation or projected and the actuals. Okay.
There's no actionable item on this. This was just for us to review.
Yes.
Okay.
Okay, anything, any other comments that want to be submitted while we're on this topic? Hearing none, we'll move on to H, which is nominations for CBLS annual appointments. Amy.
So a notice was sent to CPLS on January 4th to submit interest in being appointed for an officer position. We're now opening up the process again for 2019 and 2020. And so we're opening it up for two things. One is for the interest in officer appointments. But again, this is for the 2019-2020. Because we're also opening it up because we do have members that will be rolling off in the next year.
Yeah, who is, so who is?
So,
Gwen and I did mine. We're on that level.
so I think that we have 3 remaining members,
3?
right? Yes.
4 of these, so it's us 3 that are left. Because I have this year and next year, based on a 4-year. That can't be, then.
No, you want to be on this year and 2 more.
This year and 2 more, correct.
We got this year and next. It's all you.
Okay.
Don.
John's off.
Oh, he rolls up this year.
Mhm.
Oh,
We all roll up. Yeah.
Look forward to participating as a public member.
Yeah.
At the open session at the beginning, Lou, I have a feeling you'll be there.
Can you speak? Can you say anything as a public member on the?
I opened it at the beginning, and there's an opportunity. We do have the hang up. Okay, sorry.
Okay, so that's it. That was just a discussion.
So yeah, so I have, so I will continue to operate as just filling in for the meetings in this year?
Mhm.
Okay.
Can we just go Robin's chair for the year?
Well, no, we can't.
Oh, no.
Okay.
But if anyone else is interested in officer, send to me a letter of interest. And
Do we have, and obviously we're open for the new membership.
we've already, The recruitment period already closed, we've received 15.
Wow.
Really?
They say what?
15.
Wow. Very good.
Any other comments or questions on section H? Okay, hearing none, I think that that is going to take us to the end of the public open session of our meeting. And so we will adjourn the this section at 1:43 p.m. Thank you all for participating. And he'll tell us when we're clear. Clear.